May it please,
Please, Lord.
This one, the case is not in board. The Lordship was pleased to reserve the judgment of two matters. Lordship, but one matter was left out, Your Lordship. That Moni Mojumdar, Shyamoli Mojumdar, Mr. Atal Tiwari and I.M. Mojumdar was there. The Lordship was pleased to fix them, Lordship reserve for judgment. I've verified, Your Lordship, one of the accused persons, Shyamoli, her appeal is pending before this court.
Oh. It is what? There's only two appeals.
Then Your Lordship may list the matter, maybe please to direct the race fee to list the matter again, so that other matter be heard, or Lordship may fix a date, may please to fix a date for.
Okay, then. Then we'll release from part CAV
Yes,
and then hear the other matters.
yes.
Get those matters listed tomorrow. We'll list it tomorrow.
Yes.
May it please, my lord. My lord, with the consent of the other side, I beg to mention item number 10.
Yes.
My lord, the appellants are likely to engage some other set of counsel for this matter.
Mm.
Therefore, 4 weeks time may be granted.
You are appealing?
I'm appealing for the appellant, my lord.
Okay. Your good name?
T. Chakraborty.
On request made by T. Chakravarti, Learned Counsel for the applicant. Just the matter after 4 weeks.
I'm deeply obliged.
May I please, Your Lordship? Lordship, no, with the consent of the other party also, I recommend item number 13, Your Lordship.
No mention slip.
Here in this Lordship, the engaged counsel is not well physically. So matter may pass on 4 weeks, Your Lordship. And
Who's the engaged counsel?
the engaged counsel is SD.
Is it TG Manda?
The TJ counsel, TJ Mount is leading in this matter, Your Lordship. Engaged counsel is there, Your Lordship. SM Abdullah, Your Lordship.
On request made on behalf of SM Abdullah, Learned Counsel for the appellant. List the matter after 2 weeks.
Outline.
May I please, Your Lordship? I beg to mention item number 9, my lord. Kindly adjourn for a week's matter.
Here also no mention slip again.
My lord, for the last night I am facing stomach problem, my lord. I am unable to appear. my lord.
Yeah, HR Chowdhury.
Yes, my lord.
On request made by HR Chowdhury, Learned Counsel for appellant. List after 3 weeks. Yes.
I beg to item number 12, my lord. Finally, may be taken on next week, my lord.
12 goes with 11.
Yes, my lord. 12, I am for Mika Story, my lord. I'm on behalf of ISC.
Okay, on request made on behalf of ISIK, Learned Amicus Curiae. Appearing in criminal appeal, jail 98 of 2017. Live in matter
On 8 or 13, my lord.
up to 2 weeks.
Obliged.
May it please your lordship. My lord, item number 24 supplementary is that NDPS matter which I have virtually argued. Only today was your lordship has fixed it because I had filed an IA for suspension of the sentence. Your lordship was of the opinion that your lordship will dispose of the entire appeal because I had virtually argued the entire appeal while arguing the IA. Only few citations and judgments were to be given to your lordship. So, and I took a liberty to upgrade this matter when it would be listed if your lordship remembers.
A little difficulty on my part. I was under the impression it was on 2nd. First, I could not take out the judgment. So if your lordship takes it up today, let him finish. I'll argue tomorrow.
In that event, my lord, we'll finish it off on tomorrow. Your lordship will fix it on tomorrow because she is not prepared, my lord. I'm ready to accommodate her for a day, my lord. But let us not make it piecemeal arguments, my lord. We'll finish it off in one day, my lord, because hardly I have any arguments to make.
Item number?
Item number 24, supplementary.
other parted matters were there, so I didn't notice this. I thought it's on
I'm
second.
accommodating, my lord. That's it.
So tomorrow, Lordship will take step.
Third, Mr.
M. Biswas.
In Biswas, Learned Counsel for April, also had MSS Jan in addition to the Assam. List this matter for hearing again on second.
Tomorrow.
Second, Lordship, tomorrow.
But tomorrow again, I'll upgrade it, my lord, with a lot of people. I'm deeply obliged.
Item 20 to 23 of supplementary list, part of care.
I come on, case number. So, my lord, Lordship may take note of the criminal appeal 414. Item number 21 of today.
Yes, please.
All these accused, 8 persons have been convicted, no?
But one paper को करने का.
ইয়াতেতো 8টা আছে না? 8টা আটাইটা কনভিক্ট কৰিছে। কোন এক্সপায়াৰ কৰিলে? Let's go. Lord, Lordship has seen by this time. Again, Lordship will kindly come to paper book Criminal Appeal 414 of 2019. That your Lordship will take up. Yes. Lordship will find at page 2.
Page 2.
Page 2 of the paper book. There were 8 accused persons. And out of them, except number 1, this is Fakruddin. He has been shown as absconder. No appeal, nothing. He has been shown as absconder. Therefore, he remains aloof. Now, next is Abdul Hakim. I am representing him. We are representing Abdul Hakim, number 2. And then again, Lordship will find 3, number 3, Abdul Karim. No appeal has been filed. I am told that he has expired meanwhile.
Okay.
He has expired. And then Abdul Rahim. I am representing him. These 2 appellants, number 2 and 4, Abdul Hakim and Abdul Rahim. I am representing these 2 persons who have been convicted for life, RI for life. Rest, Lordship has already seen. 5, 6, 7, 8. All they have also been convicted, and they have prepared jail appeals. Lordship has heard my learned friends. Now, therefore, I'll be first placing my case because I'm representing holding brief for Abdul Hakim and Abdul Rahim. Then, if Lordship wants me to address on the other in general, then I may make certain submission. So I will confine basically to my appeals against these two convicts. So Lordship has noted that this occurrence took place on 13/4/08. 13/4/08 at 7 p.m. That is the recorded version in FIR at page 1. Page 1, right-hand column. Above this chart, Lordship will find date and hour of occurrence 13/4/08 at 7 p.m. And that was reported on 14/4/08 at 3 p.m. Left-hand column, chart, first column. That was reported on 14/4/08 at 3 p.m. Delay of 20 hours. So it was a belated FIR recorded, filed and registered after 20 hours of the occurrence. Then Lordship will kindly come to the Azahar at page 4. This is exhibit 2 in the main case. This Azahar was filed by the informant Srimati Rumena Khatun, who is the wife of the victim. Wife of the victim filed this. So there they have given the name of the accused persons. Page 5, my lord. Sir, I have the honor to state that we have been in bad terms with the above named accused persons with regard to certain issues for some time. Since after the dispute arose, the above named accused persons are in the search of opportunity to cause harm to us. At about 7 p.m. on 13/4/08, the above named accused persons came to my residence in a group and called my husband Mohammad Ajibur Rahman on the pretext of discussing certain important matter. Then, when my husband pulled out the bicycle from our residence, I held a lamp to show him the road to outside, and I saw the accused persons in the gleam of the lamp. But as my husband did not return home within the night, I informed the matter to the people in the morning, and when people caught and questioned accused number 5 and 6, they confessed that they had killed my husband. Kindly note, my lord, here this specific allegation is made against 5 and 6, accused number 5 and 6. Hobby and 6 is Aijul. They say that accused number 5 and 6, they confessed that they had killed my husband and kept his body buried. Later on, people handed accused number 5 and 6 to the police. Therefore, pray your good self to investigate. The very content of the FIR shows that this was subsequently filed after all these things came to their knowledge, and they have the FIR has mentioned about all this, that there was some grudge, there was some quarrel between them, they were not in good terms, and that 5 and 6 confessed. All that has come out. That the delay in submission makes this to happen because this is an inflated one. New things came into being. Yeah, actual facts remain elsewhere, but then subsequently the case was developed to a great extent, and that has been reflected in the FIR itself. That lordship will find usually. I'll take your lordship. Lordship has. This was written, of course, by police officer. He has admitted it. It is also mentioned, page 5, down below the exhibit 2, that signatures written as per the version of the informant and read over to her. That is the And the case was registered under T02-201 by 34 IPC. Now, probably records will show, my lord, here, page 6, only charge has been framed only one accused person. This, as per this record. In the original record, whether it is there, charges against all should have been, but I couldn't verify your lordship's original record. Here only one name has been shown, Habibur. Only against him the charge in two heads has been framed. Original to Saishilane. Original to Saishilane. That is a part to be investigated from the records I have just pointed out. Charge is against only one.
Guyan, you just check up.
Whether this charge, framing of charge
Oh, yeah.
is against only one person.
Okay.
Whether record shows
I'll-
the other accused persons. Now, my lord, we'll check up that. Meanwhile, lordship will come to the evidence part. Lordship has read it. Kindly read once more, because I'll have to point out how my clients are implicated. That part I will have to point out, because in other cases, jail appeals lordship has considered specifically to those accused persons. Therefore, I will point out whether there are any evidence, what the name against me. Here is a case where the charge was framed under 302, 201 and 34. Common intention, participation of all, union of mind, all these are there. 34 will only then come. Otherwise not. That all the accused persons with common intention participated in commission of the crime and played a role there. And that has to be very specifically proved that yes, there was all these circumstances, that there was a meeting of mind and they took part. Whether those are there.
Lordship,
You could say, yes, influential Rahman. Wherever and claim to accused persons. It is judgment to. Judgment to question.
This Habibur is also called as Habib.
Habi.
yes.
Habibur
Lordship.
is in short called Habi.
I found your lordship.
Number
Against
5.
Bobby charges payment on 1/3/16, which was in page 6 of the paper book. And regarding the framing of charges to other accused person, Abdul Hakim, Abdul Karim, Mia Hussein, Sahed Ali, Ajizul Haq, and Abdul Rahim, it is on your lordship 16/11/2012.
15,
16/11, sir.
16, 11. বেলেগ দিনত হৈছে সেইটো আমাৰ ইয়াত অহা নাই ultimate take note of that. That was that. And I find mentioned in when the trial just mentioned it in the judgment also, but without mentioning the date when it was done, that separately just were framed against it. কোনটো page আছিলে? 69, page 69 of the trial court's judgment. Lordship will find. Now, from the records, it is confirmed that yes, it was done. Page 69, paragraph 3.
What was the date, Guyan?
Lordship on 16/11/2012.
Habibur was charged
On your lordship,
First March.
one
First
three,
March
1/3/16.
2016. Now, Procedural, kindly take up first the evidence of PW2 at page 12, the informants of evidence. I'll read it, my lord. I know all the accused persons. They are from my village. In fact, it is not two are from different village. Address shows in the first at page page 4 itself, lordship will find they have mentioned address accused number 5, resident of Romari, towards bottom lordship will find. Page number 4, bottom. All accused numbers up to 8. Then accused number 5, resident of Romari. Accused number 5, hobby. He is from a different village. Rest residents of 2, Kantulimari. That is the village of the informant. So they say they are from my village. Not correct. The occurrence took place on 14/4/08. Again, this contradicts 14/4 was information law. They say it was the previous evening, 13 at 7 p.m. They say. On the day of occurrence, at around 6 o'clock, now here, at around 6 o'clock in the afternoon, my husband Azibur was taken away from our house by the accused persons, with the information to me that they had a discussion regarding art cutting towards Romari. Accordingly, my husband went with the accused persons. I was waiting in my house, but my husband did not return till morning. During night hours, some co-blazers came to my house, and I informed them that my husband had not returned. I informed about the fact to Asghar Ali, one of my uncles who has already expired. In the morning, I informed the co-villagers, the VDP, and the village headman, Nurul Islam, PW1. Then I went to the police station at around 7:30 a.m. Kindly note this. The police came and the dead body was recovered. Police detected the bicycle, sandals, and muffler of my husband at the place of occurrence. I was also present there at that time. The police were waiting, and when the magistrate appeared there, the dead body was dug out from the spot. The dead body was my husband's dead body. The dead body was taken by the police to postmortem examination. Later, the dead body was handed over to us, and we cremated the dead body as per our rights. The place of digging the dead body was spotted by accused Hobby and Aijul. That is 2 jail appellants. Hobby, 5 and 6. Accused number 5 and 6. Exhibit 2 is the FIR and Exhibit 1 is my signature. Then cross-examination. I lost the FIR on the following day of the occurrence before recovery of the dead body. Kindly note this, my lord. It will found to be incorrect. Before recovery of the dead body. Before filing a written FIR, I also informed the police orally about the incident. So, admittedly, there was first information lost beforehand over telephone. Therefore, this is not the first information. Exhibit 2 is not the first information. This is the information given 20 hours later. First information was given over telephone. Whether she or somebody else, that will find. But she says now that the police, that before filing a written FIR, I also informed the police orally about the incident. Orally. She doesn't say telephone. Orally. She says that I visited 7:30. That part in the chief versus in the middle. He said, then I went to police station at around 7:30. That is her categorical statement in chief. Therefore, referring to that, she says that she informed orally police at 7:30. Then she says, the police immediately went to the place of occurrence. The bicycle, sandal, and muffler of my husband were lying on the river embankment. From that point of the embankment, at a distance of 1 kilometer inside the shore, the dead body was recovered. When the dead body was dug out, I was also present there. The FIR was written by the police officer and I put my signature. So, police arrived before filing the FIR. Before filing the FIR, police arrived and police has written this. After recovering the dead body and all. And she put her signature. In front of our house, a road is passing through our courtyard and it is a common village road. Well, this is a very crucial evidence which will have a bearing in deciding the whole issue. Whether all these accused persons were really there at the scene, whether they really took part, because this will have a bearing in assessing the role played by each one of them, or they were present at that time when her husband was taken, or he went out. I will say went out. He voluntarily went out with the bicycle, taking away the bicycle from his house. Now, that is a common road, just passing by the house in the courtyard itself. So everybody was coming and going that time, and they are all neighbors. They were there in the evening hours. That is what I want to indicate. These persons, except the one who hails from another village. That is why this bearing of residence. One is from Romari, the others are from Kandulimari. Kandulimari is this place of the residence of the victim. And he says that his house is just standing on the road itself, in the courtyard itself, just in front of the Lordship may visualize the situations in those areas. Houses are so situated that just by the door, outside the door, they will find the road there, common road. People used to go and all residents surrounding, they come and go all the time, they remain there. That is what has been said. So if this is so, whether mere presence of these persons will be enough to implicate them, unless there is some very specific evidence to show that they indeed took part. That is why the importance is. On the road, villagers used to pass. Obviously, common road. I could identify the accused when they came to our house with the help of lamp, Saki. The lamp Saki was not seized by the police. The accused persons are my close neighbors adjacent to our house. So they were standing there. They are adjacent to their house. They were standing outside the evening hours, 6 o'clock. It is not dark outside. It is not dark outside. Outside was still to be. Sunset was not that happened that time. It was just before the sunset. Returning everybody from field, walking, they were there. Neighbors standing on the common road. That is the courtyard, is the road. Road itself is used as a courtyard for these people. That is the situation. Therefore, say that they were all there. Saki was, she says, Saki was used inside, lamp, to show her husband the door. Maybe inside door, inside the house, there may be some darkness because there is no sufficient ventilation. Or that may be the reason. Whatever it might be, this cannot be believed because Saki was not seized. And this was an exaggeration subsequently made in the FIR. That is why I say, inflated version. Saki otherwise could have been seized by police. It was not seized that time. Even if it was used, having not seized, not proved, that version goes. Again, my lord, I am coming here. They are cousins of my husband. They are all cousins, they are relatives, residing side by side. They are cousins of my husband. We had a dispute between the accused and my husband. She has not specified with whom specifically. Accused. Before this incident, I lodged a complaint against one of the accused, namely Fakrul. If we take it that this dispute between them, it is with Fakrul, if at all, that she has specified now. I lodged a complaint against one of the accused, namely Fakrul. That is accused number 1, who is absconding. Man. He is not the appellant, he is absconding. Case could not be decided against him. He has been shown as absconder. Fakrul, that is Fakhruddin, while he attempted to outrage my modesty. That was she says about the previous. It is not a fact that for the reason of having strained relationship, that should be strained relationship with the accused, I lodged FIR against all of them. Today, accused Hobby is not seen in the court. Aijul is present. It is not a fact that no incident took place on 13/4/08 as alleged. When my husband went out from the house, he was going comfortably with the accused. That is why I said he was going voluntarily. He accompanied them voluntarily. That is one part of cross-examination. Here, Lordship has seen, she has not attributed anything, she has not alleged anything against Hakim, Abdul Hakim or Abdul Rahim, my appellants. Here, nothing has been said against Abdul Hakim and Abdul Rahim. Simply saying that the accused persons where I saw them in the outside of my house. That person is not at all believable to hold that these persons were there to commit a crime, because they say that this is their neighbor standing all there in the common road. No evidence specifically laid to implicate either Abdul Hakim or Abdul Rahim here. Nothing. She has made a statement against Fakhruddin, who is absconding, and she has made a statement against Aijul and Hobby. She says Hobby was not there on that day. Record will show whether he was there on that day or not. Present. Hobby Hassan. So she says she did not see Hobby. Whether Hobby was there on that day in the court, that record will say. But she has identified Aijul. These two persons. Two persons. But others, Hakim or Rahim, there is nothing. Then Lordship will go to the next page. This was a cross-examination on behalf of Habibur Rahman. Page 14. After lodging of the Azahar, police did not come to the place of occurrence with me. I'll listen. Police went to Matikhola Bazar for investigation. Then I went there and met the police. That person again, my lord, that portion, torn in original, here it says, probably the registry, the translator also could not decipher anything. তুমি চালে পালা যদি কিবা পাব পাৰা পিপি সেইটো কি কৈছে এইখিনি
Order regarding hobby, sir.
এই যে এইখিনি যে তোমাৰ গ্যাপ এটা আছে নহয় torn in original বুলি কৈছে চাই লওক after police had exhumed the dead body, that is the incomplete statement, my lord. We had no quarrel with the accused persons prior to the incident. Again, kindly see. We had no quarrel with the accused persons prior to the incident. So therefore, the story of having disputes, having enmity is also falsified. It has not been mentioned in the Azahar that there was quarrel. But in fact, that has been mentioned in the FIR. That is why I say, my lord, that was an exaggerated version, FIR. It was filed belatedly. Whole thing happened first. The investigation took place. Allegedly, the dead body was recovered. Some articles were seized. And thereafter, some 2 persons were caught by people, not by police, by public. And they were made to confess, allegedly. And thereupon, on the basis of all this, original to torn, na?
Original is torn, your lordship. It's reflected.
That part
in
is not there.
the paper book.
Anyway, we can skip that part. That is not that material for me. So, thereafter, the FIR was filed and it incorporated all these exaggerated versions. It is not the actual fact. No actual fact is revealed there. That is why she has contradicted herself. Yeah. That no, I never said anything about quarrel in the FIR. That is what the real version is coming out now. The Azhar was written by someone at Dhing Bazar. She didn't know who wrote it. I do not know who wrote it. The contents of the Azhar were read over to me. Having learnt about the arrival of police at Matikhola Bazar, village headman Nurul Islam and witness Javed Ali also went there with me. He says that these 2 persons went there. The village headman was informed before the arrival of police. It is not a fact that it is false that on the previous day of the occurrence, the accused persons called my husband away and that I recognized them. It is not a fact that I lost the case bringing false allegations against the accused persons out of grudge. So this enmity is a double-edged weapon. If she cannot prove that the enmity was the cause, the motive, then her statement will go in our favor, that there is a motive to implicate us. She could not locate or could not identify the real culprits, and police also could not do it. Therefore, Lordship has seen here in this PW2. So far my clients are concerned, there is no evidence at all against them, even to remotely connect them. Remotely connect them. If we take into consideration her statement that she saw them outside the house, and she admits that they are their cousins, next door neighbor, residing in the same area. So their presence is obvious there. That by itself cannot be an incriminating material to implicate them. And so far, their participation, involvement, nothing has been. Nothing is there. Even her own statement regarding other accused persons lordship has seen in my response submission are very, very weak and cannot lead to the conclusion that the other accused persons were also involved there. That will be more clear from the reading of the other evidence. Lordship will kindly come to now PW1 at page 8. She says that before police came, she went to inform this Nurul Islam and Javed Ali. What Nurul Islam says, kindly see. I know all the accused persons by name. They are my co-villagers. I know because he is from the same village, Kantulimari, my lord. He is from the same village. My house is at 2 number Kantulimari. Nurul Islam address, Lordship has marked it. I know complainant Rumena Khatun. Rumena Khatun lodged an FIR on the 1st January of 2008. He comes with a different verse altogether. He says it was on 1st January 2008. At Dhing police station for the death of her husband. On 1st January 2008, in the early morning at 6 a.m., informant Rumena went to my house and informed me that the accused person seen in the dock took her husband to Romari village for some earth digging discussion. She reported me that her husband was called out from her husband by the accused, called out her husband by the accused and did not return till morning. She informed me that she had already reported the matter to the other villagers and she requested me to go to her house. Accordingly, I went there. Before I reached the house of the informant, I reached the market. I saw that some villagers caught hold and cordoned accused Hobby, that is accused number 5, and Aijul, Habibullah and Aijul, these two, who are jail appellants before your lordship. Cordoned accused Hobby and Aijul. Hobby is not within the dock. He was declared absconder. Hobby pisot keneke ahile? Wrong, isn't it? So, my lord, here he could not identify. My instruction is, Hobby was all throughout in jail. So he must be there. He was produced. Absconder was this Fakhruddin. Number one. He is absconding till now. Hobby was arrested and he was there in jail, custody. So during trial, he must be produced. He ought to be there. So he could not identify. He could not identify. Conclusion would be he could not identify. I saw the assembly, yes. Hobby is not within the dock. He was declared absconder. When I saw this, I immediately informed Dhing police station. Kindly see. She says that she went there at 7:30 PW2 to the police. But he says in the morning she went there. She went to his house, Nazrul Islam. He came to her house. On the way, he went to the market, saw in the market that many people have gathered and 2 persons have been carried out by them, cordoned off. And then, having seen this, because his responsibility is, he is a village headman. That is also recorded at page 8, my right hand column. I am a village headman. So he immediately telephoned the police. He informed the police. He informed the police, and then he says, then the OC of Dhing police station came there and took over the above two persons. When police interrogated them before the public, they had admitted that they had killed the accused Azibur Rahman. This is a statement in presence of the public. They say, when police asked them, he says that they confessed. The above named two accused persons made a statement before the IO that they had concealed the dead body on the ground in the neighboring shore, which is situated at a distance of 1.5 kilometers away on the northern side of the house of complainant Rumena Khatun. This relates to accused this relates to accused they say when there the two persons, namely these two persons, cordon of Hobby and Aizul, that is my lord, 5 and 6, accused number 5 and 6, they were cordoned off, handed over to police. According to this witness, these two persons, Hobby and Aizul, they admitted that they had killed the deceased Aizibur Rahman. The above named two accused persons made a statement before the IO. Maybe this is the indication that statement which led to the discovery under section 27 of the Evidence Act. That might be the indication, but this will also fall true. I will place your watch. But let us take note of this. Statement before the IO that they had concealed the dead body on the ground in the neighboring shore, which is situated at a distance of 1.5 kilometers away on the northern side of the house of the complainant Rumena Khatun. After hearing this statement of the accused, we the villagers, along with the police and the above named two accused persons, went to the site where the dead body was buried, and on being shown by the accused the exact spot, we the villagers cordoned the area along with the accused. The police officer told us that he would inform the magistrate and we should await till arrival of the magistrate. After a while, the magistrate arrived. The place was dug out with the help of accused Hobby and Aizul. Then the dead body was dug out of the ground. Exhibit 1 is the seizure list and Exhibit 1.1 is my signature. Thereafter, the police and the magistrate took away the dead body as well as the accused. So these two persons, my lord, whom I am not representing, but they are jail appellants people. Aizul and Hobby. These two persons were taken into custody by police on that very day in the morning from the market, and police did not arrest them. Police did not catch them, but it is the public who caught them, and they cordon off, they pressurize, they threatened, and ultimately they said that they confessed before the police, and that is why police took them away. There is nothing in this statement about my clients, so far we are concerned, Rahim and Hakim. Hakim and Rahim, there is nothing. Their names have not been uttered by any one of them. Nothing has been said. Let us see the cross-examination. When I put my signature in Exhibit 1 in the seizure list, I could not say what were the content of it. Go on. His signature was simply taken, if he says he didn't know what was there. I have been shown muffler and sandal before taking the signature on it. The seizure list was prepared at the place of occurrence by the OC and he took my signature. I have made the statement in the court on the basis of the information received from Rumena Khatun. So he admits that I am a hearsay evidence. Whatever I have said, I have learned from her only. He doesn't owe it to himself. He doesn't have his personal knowledge on this. My house is situated at a distance of 1 kilometer from the house of the complainant. There is a public road passing just by the side of the house of Rumena Khatun, the same person, Mala. Just by the side of the house of Rumena Khatun. And the villagers used to go through the road. The name of the market where the two accused were detained is called 2 number Kandulimari Matkula Bazar. When I reached the said market, the villagers detained 2 persons there already. There were around 500 villagers present in the market. Then the police came and took the custody of the 2 boys. The police officer recorded the statements of the accused persons. I have not seen where from those 2 boys were brought to the marketplace by the villagers. They were in the market, they got them. The sword is situated at a distance of 1.5 kilometers away from the river embankment and it is open, it is an open place. The sword is normally filled by river water during the rainy season. At the relevant time, Javed Master, he is PW3, my lord. Kasem Master, PW4. Kasem Doctor, he was not examined. And many people were present. The VDP Secretary Kasem Ali and VDP President Kasem Forazi were also present. It is not a fact that the 2 accused persons detained there made any statement confessing their guilt. He has denied this such. In that incident, while 2 boys were detained in the market, there was a tussle and fight with the police officials and the public of the Sore area. So there was a fight between public and the police. I, along with some village elders, tried to intervene the tussle, as a result of which the police officials lodged a case against us, in which a case was instituted and I was acquitted in that offense. That's another very interesting fact. When the police went there, the public there allegedly took out a fight against the police. And police registered a case against some of the leaders of the public. He was one of them. They were prosecuted. Where ultimately they were acquitted. And all these accused persons who were prosecuted by police and subsequently acquitted, some of them are witnesses here. Mostly they are witnesses here. Police, there is every reason to believe that police has pressurized them to come as evidence, to give witness, to come as a witness and give evidence in this case. And for that matter, the case which was instituted against them, prosecuted, that played the role. So they are not coming instantaneously knowing the facts. In fact, they do not know the facts. Nobody has seen it. Nobody has seen the occurrence. There is no eyewitness there. And even they do not know where from these 2 persons were caught. But they found that in the market, 2 persons were cordoned off by the police, by the people, and then handed over to the police. It is not a fact that 2 accused persons, yes. In that incident, while 2 boys were detained in the market, there was a tussle, yes, we have read this. I, along with some village elders, tried to intervene the tussle, as a result of which police officials lodged a case against us in which a case was instituted and I was acquitted in that office. While there was a preparation of inquest report at the time of digging out of the dead body, I was present. But my name was not taken as witness on that inquest report. The informant reported about the incident to the OC of Dhing police station, and subsequently to that, I informed the OC while I saw the detention of the two boys over phone. Now, pausing for a moment here, PW2 says that by 7:30 she orally informed the police. PW2, PW1 says that she went to his house. Getting the information from her, she wanted him to come to her house. He accompanied her on the way, saw in the market that there are a lot of people gathered there. And then the incident he has narrated what happened. Police came, he informed the police came only then. But he also says now here that before I informed the police, it was she, PW2, who informed them. How? She has said orally. That means she must have visited the police station. If she must have visited the police station must have taken note or must have made a GD entry there. Must have either taken the FIR from her, written by them itself, then and there. Nothing is there. Nothing is there. Therefore, nobody knows what happened, but there is a chaos altogether. The police came on the information of this VDP secretary. And that is what the police has also said. This is the police case. Kindly see, at this stage, I will refer to that GD entry on the basis of which the investigation was just started. They have recorded it. GD entry at page 90, Lordship will kindly come to. Page 91. Page 91, my lord. This is how the law started moving. This is number 219. It is on 14/4/2008 at 7:55 a.m. Receipt of information over phone and moving out of OC, SI and staff. The GD entry. Now, VDP Secretary number 2, Kandulimari informs over phone that a person was murdered and his dead body was kept buried, and that in this connection, they have apprehended 2 boys. Accordingly, this GDE entry is made, and I see so-and-so, OC Dhing PS, along with SI so-and-so, Bimal Hazarika, Constable, and 1 security, 16th AP Battalion personnel proceed to Kandulimari. ASI and Bordloi remains in charge. So this militates the statements of PW2, PW1, that he went there at 7:30, 7:30. And the statement of PW2 also. PW1 says that she went there. PW2 says that she went there, but this is falsified by this, that in fact, it was on the basis of the telephone. That was the first information, what I mean to say, of the VDP secretary. VDP secretary PW1. PW1. On his information, police came. And the written FIR, which was inflated one, was submitted 20 hours later. When the entire investigation was completed, exhuming the dead body, taking it by them. Meanwhile, these 2 persons, Hobi and Aijul, they were caught by people. They took them. And that culminated ultimately to the FIR, which was written by police itself, taking into account all these facts, and she was made to sign there. No written FIR as such was filed, only police information was lost over telephone, and police acted upon that. That is why this GG entry, they approved it, Exhibit 4. Exhibit 4. Therefore, my responsible submission would be, keep years ago. Huh? Yes. Let me read the entire portion, then I'll come to my conclusion. Informant reported about the incident, OC Dhing police. So he says that the informant reported about the incident to the OC of Dhing police station, and subsequent to that, I informed the OC. That is also not correct. That is what I have said. While I saw the detention of the two boys over phone. The police, after their arrival, examined some of the witnesses at the place of occurrence, including me. I was reported by the informant about the incident on 1108 at 6 a.m. It is not a fact that no incident took place on 1108. It is not a fact that I have stated about the death out of my own imagination. It is not a fact that informant Rumena had not reported anything to me as stated. It is not a fact that the accused persons are innocent. So, well, his very foundation is missing. He says it is on 1st January 08. He is asserting this repeatedly. So this shows that he is not aware about anything. He is a person who has been told to give evidence, he has given, and it is entirely hearsay. It has no substance at all. Notwithstanding the fact that he has not also named anything except Azizul and Hobby. That two persons were caught. He could not say anything else. My clients, they come nowhere here. They are not in picture at all. Only FIR, their names were put, which was filed 20 hours later. That is why I say that was an exaggerated person, and having taken a chance to meet their grievances, grudge, they may have some grudge, we are neighbors, they put my name there, except that they could not prove anything. Could not prove anything. So Lordship has seen even PW1 is of no value so far as evidence against the accused persons, not to speak of my accused only, my appellants only, also in respect of others. This cannot be relied on to convict them. He is a tutored witness. And most probably, as I had said, the presumption would be that they have been set up as witness by police because there were cases against them instituted by police. Now, PW3, Lordship will come to. Page number 15, my lord. He is one Jahed Ali. He is also from the same village, Khairamari. My residence is Khairamari. Khairamari in Kandulimari. He is from Khairamari, different village. He is from different village. I am a teacher. He is a teacher, he says. I know the accused persons seen in the dock. Occurrence took place some 3-4 years ago on the day of first Bohag. First Bohag was not the date, in fact. Just it was one day prior to first Bohag. After the morning prayer at Masjid, I was sitting in a tea stall, and at that time, some villagers along with VDP and the Gaon Burha, that is the PW1 my lord, came there and informed me that one Ajibur, deceased, was called on by the accused last night, and since then he is missing. They also told me that some articles like a computer, a pair of slippers, and a bicycle was lying on the river bank. Then I along with the others went there and found the same. There I saw that the accused Aijul and another Hobibur was altercating with villagers. When they were asked by the villagers to find out the deceased, thereafter both of them were taken to the market, and after little interrogation by the villagers and VDP, they confessed before us that they, that is Aijul, Habibur, Fakhruddin and Sahed Ali, he has elaborated it. He has given the names of other two persons, Aijul, Habibur, Fakhruddin and Sahed Ali. These four persons killed the deceased and buried the dead body in the shore. So according to him, this Habibur has confessed that these two persons, they killed Azizul, Habibur, Fakhruddin and Sahed Ali. They killed. This is the version according to him. After some time, the OC of Dhing PS Sushil Datta arrived there, and along with him, we proceeded to the place where the dead body was buried as leaded by the accused. Both the accused Aijul and Habibur dig out the dead body in front of the villagers and took back the dead body. Police made a seizure list of the articles found in the river bank, Video Exhibit 1, and I put my signature, Video Exhibit 1, 2 on it. That much I know. So he was a son's witness that way, my lord. He was sitting there, suddenly he saw that some people have come and informed him this has happened. He went there and found that people have gathered meanwhile there, and they are altercating with these Ajibur and Habibur. They were taken into their custody, people, and ultimately when they were taken to the market, and they were questioned, probably must have trust, and they said yes, yes, yes. We all four, according to him, says they also uttered the names of Fakhruddin. Fakhruddin is now absconding, right? Fakhruddin now absconding. And Sahed Ali said these other two persons also there with us. We have killed him. That's much he knows, and he was a witness to the Exhibit 1. Those articles was seized thereby. Then cross-examination, Lordship will see. I was not examined by police. So he was not examined by police. That means he was not there. He was not relevant. Police didn't consider him to be a witness, material witness there. As such, my statement recorded in my name is not my statement. He has disowned everything, my lord. Kindly see. Gone. The whole thing goes. My lord. No evidentiary value at all. He says something before the police. He says, no, I was never examined by police. In my name, some statement has been produced. I was not that person. I have never given any statement. So he disowns everything, and therefore his evidence has no value at all. I do not know how and why, and how and by whom the deceased was killed. Exactly, he doesn't know. He was a son's witness sitting there. He was informed. He said that I came out from the masjid and was sitting in the tea stall taking tea. That time people made hue and cry. They came and informed me. I went there and I know nothing.
But Jahid Ali was shown as a witness in a charge sheet, Your Lordship, this fellow.
Hmm?
May I clarify, sir, one aspect regarding PW 1 and 2 did not see Habibur on the date when the substantive evidence was given. I have checked up the records, Your Lordship. Habibur was released on bail on 16/7/08 by the Learned Trial Court on completion of 90 days, and thereafter he was not found. Bailable warrant was issued against him. Then thereafter non-bailable warrant was issued. Then proclamation of arrest was issued on 18/3/2013, Your Lordship. 28/7/2015, and date of deposition is 8/4/14. So naturally, they'll say he was absconding, he was not seen because he was not could not be found on that day.
Then he subsequently he appeared.
Yes,
Subsequently.
arrest is sir
That's
on
what-
28/7/15.
Okay, okay. Okay, then his statement, he didn't see him in the dock, PW one says.
It's correct.
That is correct. If he was not there on the dock, because he didn't appear, he was not in custody that day. So therefore, so for that aspect is concerned, okay, fine, he was not there. But other part, what you will see, this is no evidentiary value. He knows the persons because they belong to the same house, same village, same village. Here, this PW3, Lordship has seen, he has disowned everything. He doesn't know. I do not know how and by whom the deceased was killed. The place where the dead body was buried was about 1.5 kilometers from the embankment. The river bank is about half furlong away from the marketplace. I did not see any identification mark on the seized articles, but the villagers opined that those articles belonged to deceased Azibu. I have not seen the seized articles in the court today. At the time of signing the Exhibit 2, I was not aware of the contents of it, and I signed it on being asked by police to do so. He was a seizure witness. But he says that I didn't know. I was simply asked to sign, I put my signature. I didn't know anything what was there. I could not find out, those articles he could not identify. Articles he could not identify. That yes, those articles belong to Azibu. He said, I didn't find any identification mark there. I do not know. I have not seen these seized articles in the court. Those were not produced in the court also. Those must be produced before the court and shown to the witnesses. That was not done. I signed it on being asked by police to do so. It is not a fact that the accused had not made any statement before the villagers about the killing of the deceased and buried the dead body in Sor. It is not a fact that the accused led the police and the villagers to the place where the body was recovered in Sor. It is not a fact that the accused led the police and the villagers. He has denied that. He has denied that it is not a fact that the accused led the police or the people to the place where from the dead body was recovered. So therefore he denies any statement or role played by the accused persons. Those are Azibur, Habibur, they are Aizul, Hajibur, that there was no such statement made by them. It is not a fact that the accused led the police and the villagers to the place where the body was recovered in Sor. So, well, here also Lordship has seen, so for my appellants are concerned, they are not named, there is nothing against them, not a whisper. This witness. As I have said, my lord, I am holding brief for these two persons. What I find, there is nothing in none of the witnesses. There is nothing, but I am taking your lordship to the evidence to have a clear idea about whether my contention is correct. That is what. Otherwise, the evidentiary value. So for the other accused are concerned, Lordship has seen in my accused submission, there is nothing. Nothing. Only aspect Lordship will have to see ultimately whether there was a statement leading to discovery and that has been proved. If not, then case against this Azizul, his name Gita, Aizul, Habibur, Fakhruddin, Sahid Ali, all these will also fall through. I am not representing them, they are in jail. But I must point out, so far I understand, if that is not proved, then gone. Case is gone against everybody. My clients are nowhere implicated. Then Lordship will come to the next page. PW3 further cross-submission by Habibur Rahman. Matikula Bazar is at a distance of about 1 furlong from my house. I know Rumena from before. She is related to me by village courtesy. When police came to Matikula Bazar for investigation, I went there. Rumena did not go there with me. I did not found Rumena at Matikula Bazar when police came there. Rumena told me that Habibur and Aizul had called away her husband. It is not a fact that it is false that the accused persons confessed that they called away Rumena's husband Azibur, killed Azibur, and kept his body buried. It is not a fact that it is not true that Aizul and Habibur showed the dead body by remaining present at the time of digging it out. Basically, as I find, my lord, the evidence of this witness would be only a corroborative evidence to the evidence given by PW2. But he doesn't corroborate anybody, rather he disagrees. So if I accept concurring that yes, these two persons were caught there, they were found in the market, people have gathered there and police has taken them. This must, even he doesn't admit that they made a statement before the police. Therefore, this witness is of no value here, not to speak of only against my clients, but as in general. Then Lordship will come to PW4, page 18. He is one Qasim, Abdul Qasim. He is a teacher. He is from Koiramari. He is also from different village.
This page 16,
My lord.
second last para,
Yes.
and then the page 17 last para. How do we?
Yes. Here he says, my lord, it is not a fact. Lordship has referred to page 16,
16, yes.
second verse last verse, second one.
Yes.
It is not a fact that the accused led the police and the villagers to the place where the body was recovered in shore.
Yes.
He simply says that it was not correct, not there.
And
Then in the other part, he says it is not, last line, it is not a fact that it is not true that Aizul and Habibur showed the dead body by remaining present at the time of digging it out. This is regarding showing the dead body, and the first is regarding leading the police to the place of occurrence. He says that they didn't lead the police or people to the place of occurrence. And in this page 17, he says that suggestion he has denied that they never identified the dead body. He said, no, they identified the dead body. Identification of dead body is something else, but leading police for discovery is another thing. That is the distinction here. I'm grateful to your Lord. 18, my lord, page PW4. He is a school teacher, he says. He's from different village. I know the accused persons. I know informant Rumena Khatun. I knew this is Ajibu. He was the husband of the informant. The incident took place on 14/4/08. On the day of the occurrence, I was standing at the gateway to my house. Then I heard from Jahangir and Ajibur, Jahangir, that Ajibur had been killed and that two persons were detained by the public at Matikula Bazar. Getting the information, I went there and saw that Azizul and Habibur were kept detained in the pharmacy of VDP Secretary Afzal Khan. I saw around 200 people gathering there. On being asked about the incident, Azizul and Habibur said that both of them, along with Abdul Karim Fakruddin, Toibur Rahman, Sahed Ali, and some others had killed Azibu. He has named these persons. Again, Melody, killed Azibu. Javed Ali, Hasmat Ali, Joinal Abedin, Mujibur Rahman, Government Gaon village headman, Nurul Islam, Abdul Qasim Faraji, and many other people were present. When the accused, though, confessed their guilt, on being informed, police came there and the accused persons were handed over to the police. When the police interrogated the accused persons in presence of the public, both the accused persons confessed in similar fashion. Taking along the accused, though, police went to the place where Azibur was killed, and having found muffler, sandal, and bicycle lying at the place of occurrence, police seized the same. Blood was seen in the drain of Bodo paddy cultivation, that is called Bodo cultivation, my lord. Thereafter, Azizul and Habibur led police to the place where Azibur was kept buried after his murder. Jute sheets remained sewn in that place. After the arrival of the magistrate, Azibur's Rahman's dead body was dug out. In course of the investigation, police recorded my statement. The land having Bodo paddy cultivation is about half kilometer away from the pharmacy. There were 200 bighas of land having Bodo paddy. The place where the dead body was buried was about half mile away from that place. That plot was an agricultural land, and around that time jute sheets were sown thereon. Police did not record any statement when the accused persons confessed that they would sow the place. Kindly mark this, Mala. Police did not record any statement. Lordship will appreciate that statement if it can be used for discovery and made before the police officer. It is treated exceptionally. That statement made before police admitting the crime cannot be relied. But here goes an exception. Here is an exception that if they confess and lead police for discovery, then this is admissible in evidence against those accused persons, notwithstanding the fact that this is made before the police. So to that extent, there must be a categorical statement recorded by police, which can be construed by this honorable court that yes, this part forms a statement leading to discovery. And therefore, it is an exception admissible under section 27. That is why this statement is very, very crucial, recording of statement. He says, police did not record any statement when the accused persons confessed that they would show the place. At first, I came to know about this incident from Jahangir. Jahangir is alive now. He was not examined. It is not a fact that I did not state to police that I had heard from Jahangir that Azibur had been killed. So he did not state before the police also that Jahangir has informed him. It is not a fact that I did not state to police that there was blood in the drain of Bodo paddy cultivation and that a bicycle, muffler and sandal were lying there. I did not notice whether police brought the blood-stained soil. It is not a fact that I did not state before police that when both the accused persons were making confessional statement, Javed Ali, Hasmat Ali, Joinal Abedin, Mujibur Rahman, Government Gaubura, village headman, Nurul Islam and Abdul Qasim Faraji were present there. This is a contradiction because it was not there in police statements. There was a commotion due to the delay in the recovery of dead body of Azibur Rahman, and owing to that, police registered a case against the public. And I too was an accused of that case. He was also an accused in that case. It is not a fact that Azizul and Habibur did not confess that they both, along with Abdul Karim, Fakhruddin, Taibur Rahman, Sahed Ali, and some others had killed Azibur. It is not a fact that no muffler, sandal, and bicycle were recovered from the Bodo paddy cultivation, that there was no blood in the drain, and that no paddy dead body was recovered from the place where jute seeds had been sown, the way I have stated. It is not a fact that Azizul and Habibur did not show the place where the dead body was buried. I have not seen the seized articles in the court today. It is not a fact that I have adduced false evidence. Then on behalf of the accused Habibur Rahman, I saw about 500 people outside the pharmacy of Afzal. I did not see if the public had assaulted Azizul and Habibur. Having seen the muffler, sandal, bicycle and blood at a place about half kilometer away, some people requested the police to visit that place. As per the request of the public, police visited that place. So, well, that leading to discovery, again, statement that these accused persons pointed out and took the police to that is contradicted by him. He says that having seen the muffler, sandal, bicycle and blood at a place about half kilometer away, some people requested the police to visit the place. As per the request of the public, police visited that place. And then there the body was exhumed. And one witness said, as I have already pointed out, he said that these two other accused persons, they identified them. They identified that yes, it is the body of such. So Lordship has seen here also, so for my clients are concerned, these two persons are no way connected, nothing, no evidence, no name uttered, no role has been ascribed to them, nothing. So that way, my Lord, as I submitted, there is no evidence whatsoever against my clients. There is no evidence whatsoever. And the evidentiary value, as I have been submitting, my lord, of this person against other accused persons, lordship will find it is a very weak piece of evidence, not sufficient at all. These are all sound witness. He was standing at his gate. Somebody came, suddenly informed him, he went there. The person who informed him, he is alive, he has not been examined. He admits that yes, police lost the case against me. Case was pending, I was an accused there. And he has been cited as a witness, he has come as a witness. He has deposed. These circumstances weigh heavily in favor of the accused persons, whose names are uttered by them. And the names of my clients, two clients, Abdul, Hakim and Rahim, their names are not uttered. Nothing has been said by any of these witnesses. All these witnesses, nothing. Kindly see PW5. He is the BDP secretary, Afzal Hussain Khan, madam. He's a government servant, he says, working maybe somewhere. PW5, page 21. I know the accused persons. Accused Habibur Rahman hails from village Romari. Rest of the accused persons are from village number 2, Kandulimari. So Habibur comes from another village and rest are from Kandulimari. They're her neighbor, Rumena's neighbor. I know informant Rumena Khatun. I knew this is Ajibur Rahman. He was the husband of the informant. The incident took place on 14/4/08. In fact, the 14/4/08, nothing happened, but all they are saying 14/4. But Rumena says it is on the previous evening, 13. So they are all not sanguine, not know what will happen when. See, he is also saying it is 14/4. At the time of occurrence, I had been the BDP secretary of village number 2, Kandulimari, and I had a pharmacy at number 2, Kandulimari Bazaar. In his pharmacy, my lord, people gathered and took the two persons. Rumena told me that around 8 p.m., again, can you see, at night, she initially says it was 6 p.m., then somewhere she said it was 7. Now he says that I was reported that it was at 8 p.m. On the previous night, Azizul Haq and Habibur called away her husband, Azibur, from home. This Azizul Habibur, these two names are being uttered by them. They called him away to collect their wages. That night, Azibur did not return home. Then many people gathered at the market. Then we, the members of the BDP and the villagers, went to meet Azizul and Habibur. We found them and brought them to my pharmacy and questioned them, because they say, Mala Rumena says that it was Azizul and Habibur. They called her husband. They took away her husband. That's why the people went to their house and they were found at their house and they were brought to the market. This is how he explains now. He is the secretary. Then Azizul and Habibur confessed that they both, along with Jahed Ali and Fakhruddin, had killed Azibur and buried his body. So he also says about the confession, the admission on their part, which they want to use as confession. I informed the Dhing police station about the incident over phone. He says, I also informed. Police came to the place of occurrence and we handed Azizul and Habibur over to the police. Taking along the accused, though, police went to the place where Azizul was buried. Later on says, the accused though led police to the place where Azizul was buried. There is an addition, my lord. His spontaneous statement was that taking along the accused, the police went to the place where Azizul was buried. Police took them. They didn't leave, but he then developed it, saying later on that no, the accused though led police to the place where Azizul was buried. We'll see to it, my lord, how the IO has taken it and what is statement to that effect, that it will be clear to your lordship. Later on, yes, says buried. The accused persons led police to the place where jute weights were sown, jute seeds were sown on the other side of the dead canal of river, and showed the place where the body of Azizul was buried. OC said that the dead body would be exhumed after the arrival of the magistrate. After the arrival of the magistrate, Azibur's dead body was exhumed. Police took the dead body away. Cross. Azizul and Habibur were brought from the front of Azizul's house. The distance between Azizul's house and my pharmacy is about 400-500 meters. So they were taken from house. The place where the dead body was recovered is about half kilometer away from my pharmacy. I was present there from the time the wife of the deceased told me about the occurrence to the time of recovery of the dead body. Police did not record statement of any accused or witnesses in between the time of making confession by the accused persons and the time of recovery of the dead body. Lordship will kindly note this. If we take the evidence given by this witness is reliable, then this is very, very important. Lordship has seen, my lord, basically the case is rested against the other accused persons. Because so far I am concerned, there is nothing. Other accused persons, they say it is the statement leading to discovery, confession leading to discovery. That part. There must be a statement recorded that he specifically says that I was all along there. But during that time, no statement was recorded. No statement was recorded. Police did not record statement of any accused or witnesses in between the time of making confession by the accused persons and the time of recovery of the dead body. Police did not write anything regarding the confession of the accused persons before police. Kindly see. Very categorical statement. The whole foundation is now erased by this witness. The whole foundation of the case that there was leading to discovery and accordingly dead body was discovered, statement was made, that has been demolished by this witness, BW5. It is not a fact that making of confession by the accused persons before police and us and showing of the place where the dead body was recovered by them is not true. So this was put as a suggestion to them that even your statement that they confessed it, that is also not correct. He denied, but he says that no statement was recorded. No statement was recorded. Jahed Ali, Abdul Qasem Foraji, and village headman. These are all witnesses, PW3, PW4, PW6, PW1. Village headman Nur Islam came after the accused persons who were brought to my pharmacy. Whatever police did after coming to the place of occurrence on receipt of my phone call were done on the basis of my phone call. That is why the GD entry lordship has seen my on that phone call. That is the beginning. Nothing else. No, nothing was given to them that time. No FIR was filed. I do not know when the Azahar was lost. Police questioned me It is not a fact that I did not tell before police that Ajibur's dead body was recovered at jute field situated on the other side of the dead tunnel of the river. It is a contradiction. As the arrival of the magistrate was delayed, a violent situation occurred between the public and the police. Police lost the case against the leading persons as they tried to attack the police. About 4,000 to 5,000 people gathered at the place of occurrence. One has said 200 or 500, but he says no, it is about 4,500. All these people pressurized these two persons because their names have been taken by the wife of the victim. That was they who called them. That much. Police registered case against 7 people, including Abdul Qasem Foraji, that is PW6, Abdul Qasem, PW4, Blaze Headman, PW1, Nurul Islam, Inamul, he is not a witness, and me, that is PW5. All PW5 was also an accused in the police case. Police lost the case against them. After exhuming the dead body, police wrote something. I did not put my signature on that paper as witness. It is not a fact that accused Azizul and Habibur neither confessed that they killed Azibur and buried him, nor they showed the place where the dead body was buried. It is not a fact that I was not present at the place of occurrence from the beginning. He has denied these assertions. The dead body was taken away from the place of occurrence within 2 p.m. to 3 p.m. on the day of occurrence. Police came to my pharmacy within 7 a.m. to 8 a.m. after getting my phone call. The informant was with the police from morning till the recovery of the dead body. I did not see if police has obtained Rumena's signature during that time. I did not see whose signature police obtained. So he doesn't corroborate it regarding putting up signatures by Rumena and others in any paper. He says, no, I didn't see anybody. Having found muffler, sandal, blood, bicycle, etc., lying at a little distance from the place where the dead body was recovered, it was about half a mile away, they say. On the other opposite side of the dead channel of the river, the villagers raised a furor and informed this to the police who came near my pharmacy. It was 8 a.m. at that time. I did not hear what police replied after hearing about the blood and the sandal lying there. It is not a fact that I have adduced false evidence against the accused persons. Getting the information of the muffler, sandal, blood lying there, police went there. At that time, accused Azibul and Habibur were also with police. So this particular line suggests that when they got the information that some articles are lying there like muffler, sandal, blood, police went there and Azizul and Habibur also were there with police. That is admitted. Because they were already caught by people. Police took them and went there. Where are the materials lying? People said that we have seen those materials lying scattered there. So the police went there, taking them along with the police. So the possibility of making a confession or a statement leading to discovery is totally made impossible. He says, because he is the person who informed police, who remained there with the police till the police went away from the place by taking the dead. Therefore, my full submission. Well, here Lordship has seen names of Abdul Hakim or Abdul Rahim, my clients are not taken by anybody. They were present, were not said, nor were there. But as regards the others also, what I find is only thing he says regarding that confession part. But his statement is very crucial that no statement was recorded by police of this person. That is very crucial. extrajudicial confession, that too again, my lord, leading to discovery. It's a very exceptional case, is a very strong piece of evidence, provided it is recorded in accordance with law and proved beyond doubt. Otherwise, no, this cannot be acted on. EW6, your lordship will kindly come to. We will be finishing there after only one witness. 7 witnesses are examined. He is Abdul Kasam Foraji. He is a businessman from the same village, Kandlimari. He says, I know all the accused persons. I know informant Rubena Khatun. I knew accused Ajibur Rahman. We are fellow villagers. The incident took place in the year 2007. Again, my lord, he is contradicting regarding the occurrence, date of occurrence. In the morning, on the day of occurrence, I came to my shop at Matikula Bazaar. Then Rubena Khatun came and while crying, told the people in the market that last night, Aijul and Habibur called away her husband from home and that her husband did not return home thereafter. Then we, the VDP secretary, Afzal Hussain Khan, Abul Qasim Master and many other people went to Romari village from the market along the embankment. While passing along the embankment, we saw a bicycle, a pair of sandals, and a muffler lying at the side of the embankment. This is how, my lord, police came to know from people, and people led them that we have seen that those are lying there. You should go and verify whether those articles belongs to the missing person or not. This is how the things develop. We also saw blood there. Fact remains the police did not collect the blood sample. Police did not send these articles for SFL examination, that whether they relates to anything there. Nothing. It's superficial, my lord, what I find, if I may say, the investigation. Nothing was done. Nothing was done. Then Ajizul and Habibur also came there. I'll see, my lord. Now his statement. While passing along the embankment, we saw a bicycle, a pair of sandals, and a muffler lying at the side of the embankment. We also saw blood there. Then Aijul and Habibur also came there. They went there. VDP secretary and other members of the VDP brought Aijul and Habibur to the pharmacy of VDP secretary Afzal Hussain Khan. On being questioned, they admitted that they had killed Ajibur Rahman and buried his body at a place. Then, on being informed by VDP secretary, police came there. On being interrogated by the police, they admitted their guilt and led police to the place where the dead body was buried. I too went there. A large number of people went there. The said place was plowed for jute cultivation. That was a sore, alluvial land area. Then police called a magistrate. After the arrival of the magistrate, police exhumed the body. Police questioned me. Cross. I was present when Aijul and Habibur were caught by public. I was at the market when police arrived. I cannot say whether police recorded the statement of Ajizul and Habibur after they had admitted their guilt before the police and before they led police to the place where the dead body was buried. He also denies that. He says, I do not know. That means he is in negative. Faizur, Abdul Kasam Master, Iqbal Hussain, Kabir, and many other people went to the place where the dead body was buried. Another 4,000 to 5,000 people gathered at the place around. Around 4,000 to 5,000 people gathered at the place where the dead body was buried. The place where the dead body was buried is beside the river. During summer, flood occurs here, and during winter, people cultivate this land. It is not a fact that I did not state to police that Rumena came to the market crying and told the people that her husband had not returned home. It is not a fact that I did not state to police that I, along with Kasem Master and many others, went to village Romari along the embankment. It is not a fact that I did not state before police that Aijul and Habibur came near the embankment. It is not a fact that Azizu accused Aijul and Habibur did not confess before police and asked that they had killed Habibur and buried him. Many people gathered at the place where the dead body was buried, and the agitated people assaulted the police for the delay in arrival of the magistrate. Regarding this, a case was lodged, and I was an accused in that case. All accused persons are now brought in and subsequent as witness, and they were discharged from the case. It is not a fact that accused Habibur and Aijul neither confessed that they had killed Azibur and buried his body, nor they showed the place where the dead body was buried. Police took the muffler and the pair of sandal away and left the bicycle at that place. I do not know if they wrote anything. My house is at number 2 Kandulimari. My house is about half kilometer away from that of the deceased. When I visited Romari village, I personally did not ask anyone about the occurrence. Aijul and Habibur are from village Romari, and deceased was from number 2 Kandulimari. It is not a fact that I have adduced false evidence. So up to this, my lord, Lordship has seen no one of these witnesses have ever said anything about my clients Abdul Hakim or Abdul Rahim. There is nothing. They have not said anything about our presence or our role in any way in that incident. Absolutely silent. There is nothing. So from that point of view, I submitted that, so far my clients are concerned, there is absolutely no evidence. No evidence, and they are liable to be acquitted. They have been convicted for nothing. And in general, as I submitted, Lordship will have to see now, because they are uttering the names of Aizul and Hobibu, along with them other 2-3 persons, whether any case is made out against them or not. And the whole foundation is that they confessed before the public and that they led the police and police discovered. This is the only, what I find is the material your lordship will have to consider regarding other accused persons. Jail appellants. Jail appellants. So far, my case is concerned, there is absolutely nothing. Only one material I will take your lordship to that, whether that have any evidentiary value. Before that, lordship will read the I was evidence. I was evidence. At page 28. Lordship will take a break, my lord, or
You want to take a break?
lordship, if lordship desires, because 12 o'clock, lordships normally take a break. I will also take 5 minutes break. Or lordship will, yes, after 5 minutes, we will assemble, my lord.
After 10 minutes.
Yes. Until now,
আপনার নাম তো কইছে মোর মিয়া হোসেন ফটো কই নাই মিয়া হোসেন ফটো নাই হয়তো এটাই কইছে আপনার তো এটা ভিতরে এটা লাইনত এটা কৈছে সেইটো কৰিব সেইটো মই আনিম এতিয়া সেইটো whether this is আপোনাৰ ধৰি লওক সেইটোৱে যি সেইটো মোৰতো সেইটোও নাই এটা এগেইনষ্ট মোৰতো সেইটোও নাই
So now I'm taking your lordship to page 28, the evidence given by the Ayub. হয়নে এইটো Ayub? 9 to Ayub, না? আমি কলৈকে পঢ়িলো? Sorry, my lord. 27 লৈকেতো পঢ়িলো। 6 পঢ়িলো। Now 7, my lord. PW7 is not the IO. It's not the IO. Itu পঢ়িলো নি? নাই পঢ়া। নাই। Let us read, my lord, PW7, page 28. Then only we'll get IO. One is left. Here, he's from Khoiramari, another village. I know all the accused persons. I know informant Rumena Khatun also. I knew this is Ajibur Rahman. He was husband of the informant. The incident took place in 2008. Around 6 a.m. on the day of occurrence, when I was coming out from Masjid after preparing namaz, Rumena Khatun told me crying that last night Habibur Rahman and Ajijul called away her husband from home, but did not return home till the morning. Then other people also came to that place where the masjid is situated at Matikula Bazar. Hearing Rumena, when we, the public, asked her where her husband was taken to, she said that he was taken towards the embankment. Then we people went near the embankment and saw a blood-stained shirt, a pair of sandals, and a bicycle there. Then we went to the house of Habibur and Azizur, and finding them at their house, we brought them to the bazaar. So they were found at their house. They were brought to the pharmacy of VDP Secretary Horaji. On being asked about Ajibur, Habibur and Azizul admitted that they had killed Ajibur and buried his body, and that Fakaruddin, Abdul Karim, and another person were with them. Then we informed Dhing police station about the incident and police came. Habibur and Azizul admitted their guilt before police also and said that they would show the place where the dead body was buried. Police called a magistrate and Azibur's dead body was exhumed from a sapori, an island or bank formed by river, after the arrival of the magistrate. During the investigation, police questioned me. The house, cross-examination, the house of the deceased is about half kilometer away from the masjid. Matikula Bazar is part of the house of deceased. The masjid is situated at the center of Matikula Bazar. Around 150 people were present in the masjid when Rumena was telling about her husband. Houses of accused Habibur and Azizul are also about half kilometer away from the masjid. We came to know from Rumena that last night Habibur and Azizul called away her husband and we did not know about the occurrence prior to that. Habibur and Azizul admitted inside a room that they had killed Azibur. My lord, here again the new story has come. Habibur and Azizul admitted inside a room that they had killed Azibur. He said that they were taken inside a room. Hitherto, all other witnesses were saying that this is open place in front of that pharmacy. They gathered and they took them there. But he says, no, they were taken inside a room. In the room, they said, they confessed allegedly. At that time, about 50-60 people were present inside the room. And thousands of people were present outside. So they must have been pressurized inside the room. Police did not record the statement of me and other witnesses present in the room when Habibur and Azizul confessed before police that they had buried Azibur's dead body and that they would show that place. The place where the dead body was buried is an open area. The place where shirt, sandal, and bicycle were recovered is about 1 kilometer away from the place where the dead body was buried. I did not see the blood-stained shirt, sandal, and the bicycle properly, and did not notice any special mark of identification mark. Such things are available in every household. It became too late in exhuming the dead body, and therefore the villagers got agitated and they were about to attack the police, and 1 or 2 police officers got injured, and in order to protect themselves, police moved a bit away. Seeing the violent situation, police registered a case against the leaders of the public. I was also an accused in that case. I was acquitted after the trial. There were 8 accused persons with me. So he was also one of them. It is not a fact that accused Habibur and Azizur neither confessed their guilt nor led police to show the place where the dead body was buried. It is not a fact that accused Habibur and Azizur did not state that Fakhruddin Abdul Karim and another person also committed the incident with them. It is not a fact that I did not state to police that when I was coming out of the masjid, Rumena was crying and saying before the public that in the previous night, Habibur and Azizur called away her husband. It is not a fact that I did not state in the statement given to police that after hearing Rumena, we the people went to the embankment and we saw shirt, sandal and bicycle lying there, and that thereafter we went to the house of Habibur and Azibur, and having found them in their house, we brought them to the bazaar. That was not put to say it to police, so contradiction. It is not a fact that I have adduced false evidence. During the occurrence, the OC of Dhing police station with Dr. surname was there. Rumena Khatun was with us when we went to the embankment from the masjid. I did not notice if she was with us thereafter. Though I was present there, when police seized shirt, sandal and bicycle, police did not take my signature in the seizure list. I cannot say whose signatures were taken. I cannot say whose signatures were taken by police at the time of recovering the dead body. The distance between Matikula Bazaar and the place where the dead body was recovered is about 1 kilometer. Rumena did not tell us why her husband was called away by Habibur and Azizur. It is not a fact that involvement of other accused with Habibur and Azizur is false. Therefore, now, from his evidence, these things only appear that they found those articles, they saw those articles scattered in the field. They were seized, and but he was not a signatory to the seizure list. The place where from the body was recovered, it was 1 kilometer away from that place. People went there. He says that this Azizul and Habibul, they confessed before police in a room. And they took police to the place where from the body was exhumed. That is his statement. To that extent, so he has no direct knowledge. He doesn't know who has done it. But so this circumstance, he only says that we went there, we saw these things. Now that these articles belong to this deceased, that the blood-stained shirt was the deceased shirt, cycle, this is a normal household thing. They are sandals, these are all normally available. Whether those articles belong to him, there is no such evidence coming forth. Regarding now how the IO has taken the everything, what he says, that we will find, my lord, page 34. Page 34, my lord, I am not placing 32 because this is the report, PW8 doctor's medical report. There is no denial to this, that their occurrence took place, the person died of those injuries or whatever it may be. It is of no relevance to us, because if otherwise we are not involved, something happened somewhere, we cannot be connected there. There must be some connecting materials directly involving us with that. Lordship has seen that the PW7 here, there also. So for my clients are concerned, 2 appellants, they have not uttered anything about it. Total silence about the 2 appellants, Abdul Karim, no, okay. Abdul Hakim and Abdul Rahim. Abdul Hakim and Abdul Rahim, there is nothing about them. Now, Malad Ayu. On 14/4/8, I was as SI of police at Dhing police station. Around 7:55 AM that day, VDP secretary of village number 2, Kandulimari, informed this PS over phone that a person was killed and the dead body kept buried, and that they detained 2 persons. Then OC SK Dotto and I, along with the staff, started off to number 2, Kandulimari. And I made Dhing PS GD entry number 219 dated 14/4/08 in this regard. Exhibit 4 is the GD entry book, and Exhibit 4.1 is the said GD entry number, so and so dated 14/4/8. When we arrived at Kandulimari Matikula Bazar, we saw that many people had gathered there and that 2 persons were detained. The VDP secretary and the village headman handed over those 2 persons to the police. The OC entrusted me with the investigation of the matter. I interrogated the accused persons, and they said that they had killed a person named Azibur Rahman and buried his dead body in the field that they could show the place. The names of the accused persons were Habibur and Aijul. The names of the accused persons were Habibur and Aijul. These 2 persons are implicated. When we, taking along the accused though, were going to the field, we saw an old hero cycle, a pair of leather sandals, and a violet color muffler lying near the embankment. Then Rumena Khatun, the wife of the deceased, identified all these things to be of her husband, and I seized these items in presence of the witness. Exhibit 1 is the said scissor list, and Exhibit 1.3 is my signature. Material Exhibit 1 is a pair of sandal, and Material Exhibit 2 is the muffler. Thereafter, the accused person showed us the place where the dead body was buried. Exhibit 5 is the statement of Azizul Haq made before me. Exhibit 5.1 is the statement of Azizul Haq in such terms. Later, I went with the police and showed them the place where the dead body was buried, quote unquote. Let me read, then I will come back to it, pilot. Exhibit 6 is the statement of Habibur Rahman made before me. Exhibit 6.1 is the statement of Habibur Rahman in such terms. In such terms, quote, I led the police and showed the place where the dead body was buried, unquote. Thereafter, I informed the magistrate. After the arrival of Ranbir Bora, the magistrate and circle officer, Dhing Circle, the dead body was exhumed as shown by the deceased persons, and later on, inquest was held on the body of the deceased. Exhibit 7 is the inquest report. Exhibit 7 is the signature of Ranbir Bora, the circle officer, which I am familiar with. I examined the witnesses. Later on, I sent the dead body for post-mortem examination. I prepared a sketch map of the place where the dead body was recovered. Exhibit 8 is the sketch map, and Exhibit 8.1 is my signature. I prepared the sketch map of that place also where cycle, sandals, etc. were recovered. Exhibit 9 is the said sketch map, and Exhibit 9 was in my signature. I brought both the two accused persons to the police station. Rumena Khatun lodged an azahar that day itself. On the basis of that azahar, Dhing PS case number 61 of 08 under section 302 201 34 IPC was registered. And the OC entrusted me with the investigation. Exhibit 2 is the FIR, and Exhibit 2.2 is the signature of OC Sushil Kumar Datta, which I am familiar with. Taking the charge of investigation, I questioned the complainant at the police station. I examined other witnesses also. I went searching for the other accused persons involved in the case, but I could not find them out. I arrested accused Habibur Rahman, alias Hobby, and Azizul Haq, and forwarded them to the court. Thereafter, I was transferred and I handed over the diary to the OC. Cross. On behalf of the accused Habibur Rahman and all accused persons, this cross was made. Sweeper exhumed the dead body at about 1:30 p.m. The azahar was lodged at around 3 p.m. that day. After recovery of everything, azahar was lodged, as I had said. Since morning till the body was exhumed and taken away, then in police station, she went with the police, I suppose, and there the written FIR was lost. That is how it contained some facts which were not earlier revealed, and those facts were purposefully put there, including names of my clients and all, against whom nothing has come out now during evidence. Nothing has come out. On the basis of the GD entry, I visited the place of occurrence. I did everything, that is going to Matikola Bazaar, taking the accused persons into custody, preparing the sketch map at the embankment, seizing the items, exhuming the dead body, holding inquest on the dead body, and sending the dead body for post-mortem examination on the basis of the GD entry. These were done on the basis of the GD entry. Everything, the whole investigation was conducted on the basis of the GD entry. I did not send accused Habibur and Azizul to court for getting their confessional statement recorded. There is no confessional statement in connection with their confession and their assertion that they would be able to produce the dead body that day. I did not record statements of independent witnesses. I did not record statements of independent witnesses at that time when the accused person said that they would show the place where the dead body was buried. He also admits. all the statements have said, my lord, including the PW 7, 6, that no PW 5, that no statement was recorded by police. And he admits, I did not record statements of independent witnesses at the time when the accused person said that they would show the place where the dead body was buried. If that statement was made in the presence of all people, during that time, the police ought to have, in verbatim, recorded that statement. And then they should have recorded in the diary that now, therefore, we proceed to the place as led by him. Nothing. Subsequently, sitting in the police station, writing something will not amount to a statement under Section 27. Kindly see. I had sent the dead body to the court for postmortem examination before I returned to the police station. I did not see the bicycle in the court today, which was seized, video exhibit 1. It was not produced before the court. I did not seize that lamp, in the gleam of which the wife of the deceased recognized the accused person. The lamp was not there. PW 5 Afzal Hussain Khan did not state to me that Azibur's dead body was recovered from the jute field at the other side of the death channel of the river. That was a contradiction. PW 6 Abdul Qasem Foraji did not state to me that in the market, Rumena Khatun cried and said that her husband had not returned home. PW 6 did not state to me that Qasem Master, he and many others came to village Romari and that Azizul and Habibur came near the embankment. All these are contradictions. PW 7 Iqbal Hussain Kabir did not state to me that when he was coming out from the masjid, Rumena cried and said before the public that in the previous night, Habibur and Aizul had called away her husband. PW 7 did not state to me that after hearing Rumena, they went to the embankment and found shirt, a pair of sandals, and a bicycle lying there, and that thereafter they went to the house of Habibur and Aizul, and having found them there, they brought them to the market. As I submitted, my lord, they were all, the witnesses were all accused in the police case against them. They have been cited, and they all made statement as wanted, just to support the police version. Therefore, those are not coming, and contradictions have been brought in record. Rumena Khatun was present there at the time of recovery of the dead body. At 2:50 p.m., we took the accused persons to the police station. Thereafter, the accused persons were not taken to the place of occurrence. So, well, it is not the case that they were interrogated in the police station, they made a statement in police station, and thereafter they proceeded from police station to the place of occurrence along with them. This is not the case. He admits that that thereafter the accused persons were not taken to the place of occurrence. Rumena Khatun was present there, present at the time of recovery of the dead body. At 2:50 p.m., we took the accused persons to the police station. Thereafter, the accused persons were not taken to the place of occurrence. That is, the time of preparing Exhibit 1, Caesar list, is not mentioned in it, but in the diary, it is at 9:20 a.m. Kindly see. So, no statement was recorded in the place, in presence of all these people. when allegedly these other two accused persons, Aizul and Habibur, they admitted, confessed, and they led police. That was not done. They were taken to police station. After police station, arriving at police station, thereafter, at no point of time, they were taken to the place of occurrence. So there was no question of leading to discovery going there. Their statements under 164 was not recorded. They were not sent for recording of confessional statement before the police. Here is a case, had it been the case that in fact they have confessed, what prevented the police from taking them before the magistrate for recording a 164 statement? That is the most trusted proper procedure to be followed in a case of this nature. When there is no eyewitness, nothing. Circumstantial evidence, what is that circumstantial evidence? That articles are found scattered, lying there. Strict proof of those articles are not coming for the, mainly let us take that shirt, blood staining shirt, that it belonged to the person who was killed. That has to be proved. Otherwise, how can they say? Cycle and chappal, that can be found anywhere and everywhere. We are not on that. But that the person whose body was exhumed, his blood sample and this blood sample in this shirt matches. That there should have been an FSL report to that. Nothing. And they were not sent for 164 statement. Lordship solely appreciate that the extrajudicial confession is a very weak piece of evidence. It has to be proved with very strictness. Proof is very strict here. Just cannot say that he admitted before us and we heard it. And therefore they confess. No, in matters of substance that will not go. That will not help to sustain a conviction. Then, Lordship will see the time of preparing Exhibit 1. Yes, Exhibit 1 was prepared. That is the scissor list of those articles. Time is not mentioned there. They said in diary it is mentioned. But why not in the scissor list? That has to be very specific there. One can identify, yes, it was prepared then and there. It casts a doubt, serious doubt. I did not maintain any other memorandum except the case diary for investigation. I wrote the Exhibit 6.1 after the recovery of the dead body. Lordship will kindly note this. I wrote Exhibit 6.1 after the recovery of the dead body. Though the case number is mentioned in Exhibit 1, but the case was not registered till that time. Cart was put before the horse. Registration was done much later, but at that time investigation was done. It may happen in some cases, but it must be shown that why it could not be done. Reasonable explanation must come. GD entry, okay, fine. Then GD entry, what was the information given? That a person was missing. He is alleged to have died. Dead body is lying somewhere. Nobody knows where. Police was informed. 2 persons have been detained. And then police moved. And then the whole things unfolded. Whole things unfolded. That should have been regularized. Immediate steps should have been taken so that those can be identified, those can be proved before the court of law. As I said, my lord, there is no circumstantial evidence even except what they claim, that there was a statement leading to discovery. And therefore, they confessed before us, they led us, and we discovered it. So far I am concerned, my lord, my 2 accused persons are concerned, there is nothing against them. Yeah, absolutely nothing. And they say that Exhibit 6.1 was written after the recovery of the dead body. That is very relevant because as I submitted, my lord, there is one piece which might trouble your lordship so far my one of the appellants are concerned. Whether that at all can be constituted to be a material which can be relied upon, an evidence which can be relied upon to convict them for life. So from here, lordship will see that there are a lot many contradictions proved that those witnesses 5, 6, 7, all that, they have what they have said now in the court were not reported to the police. So this is exaggerated version subsequently brought in. And as I said, this is all probability because they were subsequently, they compromised with the police because there were a case against them filed by police. And then they agreed to become witness here and they were discharged. And so they came and stated, even then they could not improve the prosecution case. There is nothing. So, my lord, in my full submission, in the evidence part, there is absolutely nothing against my two clients. Number two, Hakim and Rahim, Abdul Hakim and Abdul Rahim, there is absolutely nothing. And so far others are concerned, as I have placed only piece, my lord, that leading to discovery statement and confession, extrajudicial confession, whether that has been proved. What is that proof? Let us see that. My lord, here is nothing. Whether this part, my lord, dwelling upon that extrajudicial confession, because on the basis of that, this Habibur and others, Aizul are sought to be convicted. What is the statement? Page 35, again, Lordship will see. Page 35, IO has said what he has proved. Exhibit 5 is the statement of Azizul Haq before me. That is one of the accused, Azizul. Exhibit 5.1 is the statement of Azizul Haq in such terms, quoted. Later, I went with the police and showed them the place where the dead body was buried. Because he has admitted that this was written after the recovery of the dead body. Both this be the Exhibit 5 and Exhibit 6. This quotation, my lord, under quotation, later I went to the police and showed them the place where the dead body was buried. This here, this line within quotation will not partake the character of a statement under section 127, 27 of the Evidence Act. The evidence as such, the statement as such recorded by police must be brought before the court. And it must be proved that the statement was recorded then and there in verbatim, in the same language in which the accused persons made. And thereafter, we proceeded. It must be supported by the records, investigation records. Mere statement here, quotation within quotation placed is not enough. So also, next Exhibit 6 is the statement of Habibur Rahman made before me. Exhibit 6.1 is the statement of Habibur Rahman in such terms. I led the police and showed the place where the dead body was buried. Is not enough. It is not a statement. This cannot have evidentiary value to go against the accused persons. I will come to the law. Before that, Lordship will kindly come to that Exhibit 5 and 6. 92, my lord, page 92. Yes. Statement of accused, my lord. Page 92, my lord. Statement of accused Aizul Haq, alias Azizul Haq. of Kandlimari so and so. No time has been mentioned, my lord, here. My name and address are as given above. I am aged about 19 years. Regarding the incident, I had this much to say that for some days, Habi, Azibur, Fakhruddin, Sahed Ali, Abdul Barak, etc. and I were doing art cutting work at village Romari. Fakhruddin, A. Kasem, Sahed Ali, A. Hakim have old dispute with Azibur. Out of that grudge, yesterday, that is on 13/4/08, the said persons told me and Habibur that they would kill Azibur in that very night, and that Hobi and I had to call out Azibur from his residence. They made a threat that otherwise they would kill us too. They told that after calling him, we would have to take him to the embankment of village Romari, that they would keep hiding there, and that as soon as we would reach near the embankment of the said Romari, they would attack and kill Azibur. Accordingly, at about 8 p.m. last night, Habibur and I went to the residence of Azibur and falsely telling him that we had to collect wages for art cutting, took him with us to the village Romari on bicycle. As soon as we two, along with Azibur, reached near the embankment, Fakhruddin came with a khurki, a kind of heavy dagger, kukuri, and Sahed Ali came with a sword, and A. Kasem came with a dao. From the place where they were hiding near the embankment, the way it was planned earlier, suddenly attacked Azibur by means of the weapons they had in their hand, and thus caused the death of Azibur. After Azibur had died, we took his dead body to the land of Fakhruddin's brother and buried it there, following a discussion. When Azibur did not come back to his house till morning today, he was searched for, and people recovered his bicycle and sandal near the embankment. And when Habi and I were coming towards the market, people apprehended and questioned us. We confessed before the public that we killed Azibur and kept his body buried under earth. Later on, we led police and showed the site where the dead body was kept buried. People of the village dug out the dead body. Abdul Hakim, one of my clients, my lord, Abdul Hakim now. Abdul Hakim arranged the spade and other things at the time of digging of the pit. That means when the pit was dug, this is regarding, my lord, to exhume. Abdul Hakim arranged the spade and other things at the time of digging of the pit. Abdul Hakim. Here, this is a statement under section 161. So obviously, Lordships will be pleased to appreciate that a statement under section 161 of a co-accused cannot made before the police cannot partake the character of evidence. This can be only used for the purpose of contradiction, confronting the accused persons, to prove the veracity of this statement by confronting this statement. It cannot partake the character of a statement under section 27 of the Evidence Act also, unless these requirements under section 27 are fulfilled. Here, Lordship has seen this is a statement made by the Lordship wants to rise, my lord.
Yeah. It's up to 1 from today.
From today up to 1, we are trying to cope up with the time. we have to advance our time by 15 minutes in the morning. So today we tried. And somehow I could come out successful, but otherwise I thought probably it would be difficult. For long 47 years coming in this one time, 10:30. Now suddenly we have to change. Okay, or I'll finish. Only these two things to be placed, and then I'll place the one. I'm summing up. I'm summing up. So, my lord, before rising, Lordship will kindly say once more, we were in page 92.
Yes.
So this is a statement under section 161. In this statement, there is one line against one Abdul Hakim, one of my clients. Abdul Hakim arranged the spade and other things at the time of digging of the pit. What I understand it, this they want to say that he dig out the pit for exhuming the body. At that time he helped with that. So that is not anyway incriminating. This is not anyway incriminating. My name comes here. He says that at the time of digging the pit, he helped with spade and other things. So this is of no consequence at all against me. Then kindly come to next page. 94. Here, my lord, again, this is exhibit checks 164 statement of Habibur Rahman. Habibur Rahman. Here, if I may straightway take your lordship to the next page, 95. So Habibur Rahman said,
Before you go to 94, page 92,
yes,
here also your name figures.
Abdul Hakim,
Like fourth line.
fourth line. Abdul Hakim have old dispute with Azibur. Right, Lord, sir, I'm grateful to you, Lord. Hakim have, Hakim, Abdul Hakim. Hakim have old dispute with Azibur. This is what they say. He says, at any rate, my lord, this of course has no relevance. May have, but unless I take part in some act, in this particular act, it has nothing. That by itself cannot be. That is what I say, my lord. It goes in both the ways. In the FIR also, our names are put. This FIR was filed 20 hours later. They admit that we are neighbors, we are all cousins. We remain, we are residing next to each other. This is how. There may be something, but but see again, PW2, see again, they admitted that there is no such quarrel. I have not said that. How it came in the Azhar, I didn't know. That was the person. I never stated before police that we have quarrel. At any rate, a statement of a co-accused under section 161 has no evidentiary value against another co-accused. Therefore, my respectful submission is, this statement has no consequence at all. It cannot be a ground to convict them. Abdul Hakim. Similarly, but it's on the second page, page 95, Lordship will find. Here again, I know how the things have gone. Here, what the sentence is, last sentence. This is the only sentence again here, appearing Abdul Hakim. Last sentence, my lord. Abdul Hakim arranged the spade and other things at the time of burying the dead body. Here, they say it was at the time of burying the dead body. In the previous statement, the other one says that in digging the pit, my rule, Abdul Hakim. Digging the pit at the time of exhuming the dead body. And now he says, the other one says, Abdul Hakim arranged the spade and other things at the time of burying the dead body. One is contradicting the other. Two accused persons. Two accused persons. Even accept this, there is no whisper, anything against Abdul Hakim. Not to speak of the Abdul Rahim. Abdul Rahim, there is nothing, but Abdul Hakim, what I find is only these two statements by these two accused persons. My full submission is, this statement, being a statement under section 161, so far we are concerned, it has no evidentiary value against the accused persons, against the appellants. There can be, my lord, if there is some evidence, substantive evidence against the accused person, which needs corroboration, then of course, this can be, law is this. If 161 statement of a co-accused can be relied to confront and to ascertain the correctness. But here is nothing. No one of the accused persons, witnesses says anything about Hakim, Abdul Hakim or Abdul Rahim. Only here in 164 statement, this particular line has come, but then one has contradicted the other. One says, no, at the time of exhuming the body, he helped digging the pit, and the other one says, no, he arranged the spade and other things at the time of burying the dead body. I don't think, my lord, that this was the correct person. At any rate, both are contradicting each other. If I have helped them to dig out the dead body by making arrangements for spade and all, this cannot be an offense. If the other one says, no, at the time of burying the dead body, then that will indicate that my presence was there. This is very serious. So my response submission, whether this can be acted upon as a piece of evidence to convict me, Abdul Hakim. So far, Abdul Hakim is concerned, this is a statement under section 161 simpliciter. It doesn't partake the character of a statement under section 27 of the Evidence Act. It is a simple statement under section 161 CRPC before police. So this has no evidentiary value against that Abdul Hakim, and that cannot, on the basis of this alone, he cannot be convicted. He cannot be convicted. That is my case. So for my two clients are concerned, that is my case. So only this line, what I find in these two 161 statements against Abdul Hakim. Otherwise, there is absolutely no mention their name. And this, in my response submission, it has no evidentiary value at all to convict when there is nothing otherwise substantive against this person. Then next question, my lord, since I was submitting about the evidentiary value on the other part for others also. There, my response submission would be whether this statement at page 92 or 95 can partake the character of a statement under section 27. What is the requirement? This is, kindly see, because the fact remains now that 164 statement was not there. No controversial statement. This is a statement before police. Otherwise, this is hit by section 26 of the Evidence Act. It cannot be relied upon. But if the prosecution can brought in that no, we can carve out the distinction between a statement under section 25 and 27, then in that case it is admissible. Because that particular statement leads to the discovery on the basis of which it was done. First, in that case, my lord, my first submission is, Lordship will see, this statement, the IO has stated in his evidence, Lordship may remember, IO has admitted that these statements were recorded after the recovery of the dead body. Am I correct, my lord?
Yes.
Page 34, Lordship will find. No? This submission is in law. So for the other accused persons are concerned, convicts are concerned. Hmm. Now, Lord, there is a statement. Yes.
Page 37.
Yes, page 37. I am grateful to your Lordship. Lordship has rightly noted it. Last but one para. I wrote the exhibit 6-1 after the recovery of the dead body. Though the case number is not mentioned in exhibit 1. So, this exhibit 6, exhibit 5, no question has been put. But it is same thing. Exhibit 5 and 6, Lordship will presume exhibit 5 and 6 were written after the recovery of the dead body. So it is not a statement leading to discovery. Discovery has been done, and thereafter recording has been done. They were taken to police station, and from police station they were never taken to the place of occurrence. Discovery means what? Leading to discovery means one has made a statement in the police, before the police. Then police following that statement takes them, and the accused persons help police to go to that site. They point out the site, and accordingly they search and they find. That is yes, to that extent. Here it is not there.
That has been discarded by the High Court,
Hello?
page 13, section 27.
Look, I can't hear you.
This discovery
Yes,
has been discarded by the London Trial Court, page 79
yes, ma'am.
in the judgment.
Right. 79. There is no discovery on the information purportedly given by the accused, and as such section 27 evidence is not applicable in this case. Lordship has rightly pointed out. I am grateful, my lord. So,
I think it's therefore there's no requirement
no requirement, right? But then what I say, my
for
lord,
arguing on this point.
true, my lord, I am grateful, my lord. The trial court has already discarded this. Trial court has already discarded, but the evidence part only this is coming. That is why I am pointing. So there was no, as it says, rightly so, my lord, because discovery statement, it was recorded after the discovery was made. After the discovery was, so it was rightly discarded. In my full submission, therefore, there is no material at all. Even that person or discovery, when there was no discovery, no confession, 27 doesn't get attracted. So what is the evidence, my lord? No evidence for others also. Am I clear to your lordship's, my lord? I'm grateful. Page 79, second paragraph, last 3 lines, very categorically trial court has said. Lordship.
No. Carry on.
Proceed.
Yes, my lord. Therefore, my lord, I need not bother your lordship with other things. That is the whole picture I have placed before your lordship. So for my clients are concerned, there is absolutely nothing on record to sustain the conviction. Nonetheless, they have suffered, they were in custody for few months. From the date of judgment till they were released on bail, they were in custody. So from 13/5/2019 to 23/1/2020, that was the 23/1/2020 was the date when this honorable court granted bail. Subsequently, thereafter he must have been released. So from 13/5/2019, he was in custody. Both of them were in custody. When the judgment was delivered, they were taken to custody. And then date of bail was 23/1/2020. So my response submission is, my lord, not that the two appellants in this appeal are entitled to acquittal, and I will respectfully submit that even other accused persons who are in jail presently before your lordships by jail appeal, there is no material against them also to sustain the conviction. So appeals may be allowed, my lord, they should be set free. That is my full change. Yes, it is. 27. Well, again, we'll discard it. So then, my lord, I sum up here, my lord. I conclude.
Lordship, if your lordship permits, can I do my part tomorrow?
Meantime, you can prepare written arguments. Repeat the same one. Just say, list the matter for further hearing, second. Otherwise, repeat the same order.
Yes. Public.
One of daily.
May I please, your lordship. Planet Senior Council, we lack in the court number 7, lordship. Please, the mayor, apart times, lordship.
Who's the senior counsel?
MK Chaudhary, lordship. I'm the respondent, lordship.
Lordship, may I just point out, Lordship? Lordship, this WPC is filed against an order passed by the learned CAT for the allotment of years in the All India service. Now, Lordship, I have gone through the brief, and my feeling is that, Lordship, these persons against whom the petition is filed, they have already retired from service. In my view, Lordship, I think this matter has become infructuous. I have written to the authorities, maybe we will not be pressing it. Let it be after 2 weeks, Lordship.
Okay, you are appearing for the petitioner
I am appearing for the petition, Lordship.
on request made by Mr. R.K. Chaudhary, the Deputy SGR.
Lordship,
List the matter after 2 weeks.
Lordship. Because as it is, they have written nothing actually less.
Two.
May I please, your lordship, my lord? In this case, my lord, the petitioner was convicted for life, my lord. Imprisoned for life, my lord. In the instant case, my lord, there are 9 witnesses and defense examine none, my lord. Your lordship kindly come to the, my lord, there is a GD entry, my lord, first, and that was not exhibited. On the basis of GD entry, my lord, the investigation has been started. And next day, FIR has been filed. Your lordship filed the FIR, my lord, on my lord, page 5, my lord, of the paper book.
Mr. Chaudhary,
Yes, my lord.
can you conclude today?
No, my lord. I will take 1.5 hours.
The issue is this, we are sitting only up to tomorrow.
So,
After that, we don't know when we are going to sit. To keep it parted will be little dangerous.
I leave it to lordship, my lord, if you lordship.
Jahan,
Otherwise, not a very long matter. Circumstances, evidence, Lordship has to see whether it's at all the chain is complete. Otherwise, not a very long matter, but then there are witnesses 9 in numbers, and there are few contradictions. And
then should we
Yes,
continue?
yes, my lord. My lord, FIR is page, my lord, 5, my lord. It was filed by the PW1, my lord. And my lord, there are 2 witnesses, 2 accused person, my lord. One is Mukul Deka, another is Dipankar Deka. Dipankar Devka was juvenile, my lord. That is why his case has been remanded back to the juvenile court, my lord, of the High Court, my lord.
Who's juvenile?
Dipankar Devka, my lord. Another accused number 2.
Yes.
My lord. May I read the FIR, my lord, first? Humble submission is that at about 8:50 p.m. on 27/7/2008, as my husband Kusal Deka, son of so and so, was on the way back from home after shopping at Satyabari Bazaar, all of a sudden I heard a scream, "Please do not kill me, please do not kill me," on the PW road near the fire station, Satyabari. That is important, my lord. Thereafter, taking an open lamp, I went there, ran from home, my lord. That lamp is important, my lord, from home, and saw the above number of accused person intercepting my husband, hacking on the neck with sharp weapon. Seeing me, accused ran away from the place of account, and my husband died on the spot. And therefore, I took necessary step in regard after investigation into the matter. It was filed on the next day of the incident, my lord. There is a GD entry, my lord. That GD entry was not exhibited, my lord, in this case, my lord, on the basis of which, my lord, investigation has been started, my lord. This is nothing but a, my lord, 162 statement, my lord, under CRPC, my lord. If it is a 162, my lord, CRPC, my lord, it was hit by 162 CRPC, then nothing but a 161 statement, my lord. Then, my lord, charge has been framed, my lord. Next, page 7. That on 27/7/2008, at about 8:50 p.m., near Assam State Fire Service Office, Satyabari Town, PWD Road, under jurisdiction Satyabari PS Borbeta, in the distinct further of common intention, you wrongfully restrained Kusal Leka. The incident took place near Assam State Fire Service Authority in the PWD Road, not in the house of the informant, in front of the house of the informant, my lord, as per this, my lord. Secondly, that on the same day, time, and place of in the further common intention, you committed the murder causing by death of Kusal Deka. That is the second, my lord. Then you will say, come to the, my lord, evidence part, my lord. Deposition of PW1, my lord. She was the whole case is based on circumstantial evidence. She was coming to the place of occurrence, my lord, immediately after the incidents took place. And as per her version, she saw that accused person will flee from the place of occurrence, my lord. May I read, my lord, her evidence, my lord? I know the accused person, but the accused person were not identified in the doc, my lord. There are two accused persons, my lord. I know the accused person. She did not say this is the Mukul Deka, this is the Dipankar. If they were not identified in the doc, my lord. This is Kusal Deka was my husband. The incident took place on 27/7/2008. Around 8:30 p.m. while my husband was returning home from Satyabari market, both the accused person killed my husband little away from our rented house by stabbing him with knife. At that time, I was standing in the front of house and I heard my scream, Mug Namaribi, Mug Namaribi. Hearing my husband scream, I came to my husband in a run, reaching the spot. She was coming to this spot, my lord, after hearing all this. I saw both the accused person fleeing the scenes of bicycle. They are fleeing, my lord, from the bicycle, my lord. I noticed knife on the hand of two accused person. I saw cut injuries caused with knife on the neck, husband, and neck almost severed. My lord, this statement was not made before the police, my lord. I come later on, my lord. This statement first time made before the court, my lord. This statement was never stated before the police, my lord. And after the injury, she noticed all these things, my lord. My husband was not in a position to speak. I saw cut injury caused with the dagger around neck my husband. Before leaving her market, my husband said to me, cook rice. I am going to market to fetch some vegetable. So I was waiting for my husband getaway. On the following day morning, I lost an azahar with Satyabari police station in connection with the incident. Exhibit 1 is the Azahar. Exhibit 1 is my signature. Police seized my dagger used in the occurrence from 2 accused persons. Reaching the place when I raise hue and cry, other people turn up there. In this, in her statement, nowhere she stated my name, my lord. This is the development, my lord. What she has stated that I saw both the accused persons fleeing from the bicycle with 2 knives to the accused person. I saw 3 cartons. This was not made before the police, my lord. First time she made before the police, my lord. And omnibus where she made the allegation against all the accused person. The specific role of the accused person was not mentioned, my lord. Next cross, my lord. We are residing in a rented house. At the time of occurrence, the name of our landlord was Nipen Chaudhuri and his wife name was Bhanu Chaudhuri. A person, Bodo community, was residing in a separate house near our rented house. I do not know his name. The said person residing there with family. The place of occurrence 12 feet away from our rented house. He did not mention that he was incident from 12 feet, my lord. That was not mentioned, my lord. The fires are situated near our rented house and there is no other residence there. If your lordship go to the, my lord, sketch map, it is 300 meters away from this place, my lord. The fire station on the PWD, where incident took place. I will come later on, my lord. The fire station situated near our rented house and there is no other resident there. The employee of the station had been doing their duties round the clock. The employee of the fire station and the member of the Board of Engineers had heard my husband scream, but no from the fire station and that Board committee people were examined by the prosecutor in the instant case. The night on which the incident took place was dark one. None was present at the place of occurrence. When I reached there, after my elevation, some 40-50% turn up. That is important, man. No one is examined. If I do not know if the Gambura came to the place of occurrence, my lord, Gambura was not examined. The employee of fire station, member of the aforesaid family residing the tenant near our rented house, arrived at the place of occurrence, not examined. The employee of the fire station informed police if the incident after about half an hour, police from Satyabari arrived there. I pause here, my lord. That is the GD entry, my lord. 651. That was not exhibited. IOS, my lord, admitted. And it was informed by the employee of the fire station. That was not examined. No employee from the fire station was examined in that case. Half an after the incident, my dead body was taken to Satyabari PS. At first, I informed police verbally. On the following day, I lost Azahar at the PS. On the following morning, police seized 2 knives. Police informed me about the said 2 dagger. Neither my signature was obtained nor I was shown the said knife. At the time of occurrence, my husband was wearing a pair of trousers shirt. My husband wearing apparel was stained with blood coming out of injury. Police seized wearing apparel. Although police has sent the wearing apparel and knife also, but it was not sent to the FSL, my lord. I am saying, my lord, withholding the material from the investigation, my lord. That was not produced before the court. Then the prosecution case, my lord. I was shown. At the time of occurrence, my husband wearing a pair. My husband wearing a pair was there. Injury. There was a blood at the place where my husband was lying. After arrival of police, water was poured at that place. At that time, one thing that blood was not collected, my lord, by the investigating officer, my lord. At the time, police personnel present. My husband never told me that he had enmity with the accused person. There is no motive of murder of the accused persons, my lord. This clearly stated, my lord. See, when she was cross-examined by the witness. Before my husband death, as he used to work as a brass material worker in the house of accused Mukul, we had visited them. Satyabari PS is about half kilometer away from our rented house. It take about 10 minutes for reach from police station from our rented house on the foot, and the road was in a good condition. At about 7 a.m. on next day, I did not write the Azahar. It was reasoned in presence of police. I do not know the name of the petition writer who wrote the hazard. One important thing is that normally it is not necessary to examine the petition writer. Here in the state case, it categorically stated that I do not know the writer of the hazard. That itself shows the hazard, who has write the hazard, that was not mentioned. Although her signature is there, she do not know the content, my lord. Preponderance probability, my lord. There's judgment, my lord. I will come later on, my lord. It was written as per my version at that time of occurrence, 3 sons. At the time of eldest sons were 14 years, second is 11 years, and the youngest is 8 years. My lord. Hearing my husband scream, I rushed to the place of occurrence alone. When he heard about this, my lord, he screamed, my lord, then he went to the place. Later on, my son went to the place when I hue and cry, noticing the incident at the place of occurrence. I stated before police the hearing of my scheme, other than residing near our rented as employee of has arrived, place of occurrence. I was not produced in the court for recording my statement. 164 statement was not recorded. It was not fact. I did not state before the police that at that time we are in the rented house. It is not fact. I did not state before the police that on the day of occurrence, the accused person has stabbed my husband with a knife at a distance from our rented house. It is not fact. I did not state before the police on the day of occurrence. I had asked to cook rice. He would, after coming back, for that reason, I had been waiting in front of a rented house. It is not a state that I have not stated before the police. My husband has shouted Namaribi, and that hearing scream, I rushed there and reaching the spot. This statement I will categorically stay, my lord, where I say it is not a fact, not a fact. That statement was not said by this informant in his 161 statement. I had I had seen both the accused person fleeing from the scene on their bicycle. I had noticed the knife in their hand. It is not the fact. I did not state before the police. I had seen 3 cut injury around neck of my husband. It is not that no knife was recovered from the possession of 2 accused person. The accused person did not kill my husband by stabbing neck on his neck some distance from our rented house. That the accused person is not involved with the incident, that I lost the case to accused person. I am reading now, my lord, PW, my lord, 9 IO, my lord, because this statement, main statement that she stated that immediately after saw that they are fled from the place of occurrence, my lord, that was not stated before the police. PW 9, your lordship, kindly come. Then I go to the other accused person, my lord. PW 9, my lord, page 32 part, my lord. Page 32. Where he stated, my lord.
31 on the last. 31 last paragraph.
No, 32. 31 last, my lord. You can, your lordship can. Witness, have your lordship got it, my lord? Witness Gunawala Deka wrote the hazard that hearing after skin she had in the light open lamp, accused kill her, but I did not seize the open lamp. Lamp was not seized. None from the fire station informed me anything regarding the incident. That part, my lord. Witness Gunawala Deka did not tell me that on the day of occurrence, they had been in their rented house, that a little distance ahead of their rented house, 2 accused persons caused the husband injury with knife, that on the day of occurrence, he had been prepared rice, that on being told she had been waiting gateway and going around, she had been 2 accused persons armed with knife, flee from there by means of bicycle. If this statement has been made first time, my lord, if your lordship has omitted this statement from PW1, there's nothing available, my lord. I tried to say, my lord, if your lordship, that part is, my lord, Gunawala's, my lord, seen the accused person has fled from the place of occurrence with knife, that part is not available, my lord. Then nothing available in PW1 statement. Then your lordship come to the PW2, my lord. Page 13, my lord.
Post PW2.
Yes, my lord, page 13. His name is Ripun Dekamala. I know the accused person and complainant. I knew this is Kusal Deka. The incidents took place on a day about 5 years back, around 7:30 p.m. on the day of incident. I heard that Kusal Deka had been killed and his dead body had been left. On the following day, when I come to the PS, I saw two accused person being kept tight in the PS. I also saw there say that the Kusal Deka there. I noticed injury on the neck of the deceased. I did not ask the informant Gunamulla Deka anything about the occurrence. Police seized two knife at the place of occurrence, my lord. That is important, my lord. There is some other version also, my lord. I come in later, my lord. Exhibit to Sheikh Sijal, exhibit 2-1 is my signature. My statement was recorded in the court. My statement exhibit his signature. Next important, my lord, Sijal list exhibit. I do not know the content of exhibit 2 of the Sijal list. If he do not know the content of the Sijal list, my lord, only he mechanically put the signature as per instruction of the police, my lord. Then how can, my lord, it will be accepted evidence, my lord? I have not seen the seized knife in the court. Knife was also produced before, not produced before the court. I know where from police seized the knife, those knife. Seizure witness saying. It is not the fact that I have falsely deposed that police brought the knife from the Namkola and the police did not recover the knife. I have falsely stated that I saw cut injury on the neck of the deceased. Witness categorically stated that he has falsely stated that he saw the cut injury on the neck of the deceased. And I did not state it before the police. He never said before the police. Police took me to the court on their own way to get my statement recorded. Police called me to the police station at 10 a.m. They produced me in the court 2 p.m. It is not even I made the statement by the I was tutored by the police. This witness was not declared as a hostile witness, my lord. But his evidence is, my lord, acceptable by the court, my lord, that she was falsely deposed before the court, my lord. Next, PW3, my lord. Because, my lord, I am arguing all these things, there are two parts. One is, my lord, my duty is to prove the preponderance probability. It is duty of the prosecution to show the case has been proved beyond all reasonable doubt, my lord. And they have to put all the question in the tier 313 statement. That was not done in the instant case, my lord. But material has been taken by the, my lord, learned, my lord, session judge, my lord. PW team, page 15. I know the complainant. I knew this is Kusal Leka. I know two accused person. The incident took place on the day 5 years ago, around 8 p.m. on the day. I heard that two accused person had assaulted Kusal Leka. He is a hearsay witness, my lord. I do not know as to why they assaulted him. On the following day, I went to the police station along with the public. The accused person had been taken to the police station on the previous day. After our arrival to the police took out the accused person from the locker, asked them to say as why they killed the Kusal Deka. This is not permissible evidence as per law. Police, my lord, in police lockup, they were called from the police lockup, my lord, taken up from the police lockup, and they admitted some part. This is not, my lord, admissible evidence as per law, my lord. The accused Mukel Deka confessed before us that he had killed Kusal Deka by stabbing him and with a knife fitted with a white handle. Thereafter, we returned home. I did not see Kusal Deka dead body. I do not know about the injury present on the Kusal Deka body. Police obtained my signature on the seizure list. Police seized two knives. I produced the code for recording my 164 statement. For recording my statement, exhibit 4 of my statement, exhibit 4.1 and 4.2 are my signature, who is the seizure of my signature. I did not see who assaulted killed Kusal Deka. On the following day of incident, I went to the PS along with public. More than 100% of village had gone to the police station with me, but not a single witness from the villager were examined. Police took out two accused persons from the lockup of PS in our presence. They had been kept in PS since the previous day. That took the accused person told before us all these things they had taken out of the lockup. They are in the lockup. They are in the police custody. And this admission has been made by in the police custody. There is no evidentiary value in the eye of law, my lord. It is not the fact that I did not state accused Mukul kill Kusal Daga by stabbing with a knife fitted with handle. I did not state thing before magistrate too. Police took me on vehicle to produce before a magistrate. I did not state thing before magistrate too. He did not state before the magistrate. Police took me to their own vehicle to produce me before a magistrate. I was told that they had taken for getting my statement recorded. Police did not obtain my signature in a separate sheet of paper. I only put the signature before the magistrate. I do not remember where I put my signature exhibit 2 in the seizure list. He does not know anything. I have not seen the seized knife in the court today. It is I have falsely deposed Mukul Daga does that he had killed Kusal Daga. Basically, he has said two things. One is he is the hearsay witnesses, my lord. He does not know about the seizure, my lord, anything about the seizure. Third thing is he has made admission before the lockup in the police station, my lord. That all the evidence is not admissible in the eye of law, my lord. Then your lordship kindly come to the, my lord, next page 17, my lord. PW4. I know the two accused person and the complainant. Every, my lord, witness has not identified the accused person in the, my lord. They are not mentioned the name also, my lord. Omnibus way said there are two accused person, my lord. I know this is Kusal Deka. Kusal Deka died in the year 2008, 6 years ago. I heard that someone had killed Kusal Deka. I heard from the public that accused Mukul Deka had killed Kusal Deka. This is hearsay evidence, my lord. When I went to see the dead body, I noticed cut mark on the neck of the deceased. I did not see the incident. I did not meet police at the place of crime. Police did not question me. He is hearsay witness, my lord. That is why he was not questioned. I do not know how Kusal Deka died when cross-examined. Police did not question me. I do not know how Kusal Deka sustained injury on his neck. Yes, said madam. I know nothing about the incident. Then PW5, who is the brother of the my lord? Deceased person, my lord. I know the accused person and the complainant. This is Kusal Deka was my younger brother. The incident took place around 6 to 7 p.m. one day 5 to 6 years ago. In the afternoon on the occurrence, this is Kusal Deka had a quarrel with the accused person over some money-related matter. Then the accused person threatened Kusal Deka would cut and assault him. In the evening on the day, accused person were lying in the ambush, a bunch of seeing me. Accused person hide themselves by covering their head on the faces. At that time, leaving his workplace, Kusal Deka asked me to accompany him, but I told him to leave the place of some time. My lord, he is not staying in the place of occurrence. They are staying long, my lord. There is a distance, my lord. And if I am there, suppose the incident took place before the High Court, my lord, anything happened before the CJM, my lord, how they are connected, I do not know, my lord. In the pawn shop of the, my lord, before the CJM court, my lord. After 10 minutes, Kusal arrived in front of house. Accused Daipankar cut hold his hand. Mukul Deka showed him neck with knife. As Kusal shouted, the Gunawala came out. Then accused fled the bicycle. This evidence has been gathered. He is hearsay witness. Later on, come, my lord. He has heard all these things from the house, from the my lord, other persons, my lord. He is a hearsay witness. When Gunawala raised arm, turned up there, arriving at the place of occurrence, I was asked Gunamala about the incident. She narrated about me about the same. This has been stated by Gunamala to the PW5, my lord. This incident, my lord. Kusal Deka sustained cut injury on his neck. He died on the spot. I saw Ripon Deka, Arun Tamuli, and many other persons at the place of occurrence. I took Kusal to the police to handcuff. Gunabala lodged an azhar. Police arrested the accused person, held the inquest, their dead body, exhibit 5 inquest. On being interrogated police, the accused person confessed that they had committed the offense. It was all the statement that has been made before the police. No evidentiary value and dialogue. That what he has stated, there's this Dipankar Kodhor, it was narrated by Gunabala before him. She is a hearsay witnesses. He is a hearsay witness in this case. Kusal and I used to live separately. At the time of occurrence, Kusal was residing as a tenant in the house of Nipen. At that time, Nipen Soderi was alive, cross Karmalam. At the time of incident, one Boro community along with the member of family was residing in the house of Nipen Soderi. At the time of occurrence, Kusal Deka was unemployed. I came across in front of Namghar at Tamuli Subha around 6:50 p.m. on the day of occurrence. There was a grocery shop near Namghar. At the time the shop was open, the incident took place 20 minutes after I had across Kusal. One body whose name is unknown to me informed me about what happened to Kusal. Then I went to the house of Kusal and found beside a bamboo grove near the house along the road. I found Kusal Deka dead. About 200-300 meter people gathered there. I reached the place of occurrence. People gathered. The police arrived at the 20 minutes. Meaning thereby he reached the place after the incident. Maria said, my lord. Then I went to the house of Kusal. Have you also got it? And found him beside a bamboo grave near the house along the road. I found Kusal Deka dead. After the incident, he reached, my lord. About 200-300 people gathered. I reached place after some people gathered. Police arrived at about 20 minutes around 7 p.m. If you connected with Gunabala has said incident took place at 8:30 something, 8:30 p.m. Mal. And she come, he said about police arrived at 7 p.m. Mal. Incident took place 8:30, he said 7 Mal. The discrepancy of time Mal. 1.5 hours Mal. The dead body was lying bamboo under the group till then. Police questioned Gunabala Deka. I was questioned in the PS. I alone carrying the dead body to the police station. I put my signature on exhibit 5 in the PS. The inquest was held at the PS on the following day. The inquest took place on the next day, although body has been taken on that day. Next day inquest took place, my lord. How can the next day inquest took place? On that day, inquest should be took place in the place of occurrence of smell. At the time of holding the inquest, Gogon Daka was present along with other people. I think Gogon Daka was not examined, my lord. Not examined. At the time of Kusal Daka was wearing a pair of red, white colored trousers, half sleeve test. Kusal was stained with a blood. But that was not examined, my lord. There is no FSL report in this case, my lord. Blood also fell under the police did not seize the pair of trousers and face. Police did not collect Kusal blood from the road. I know the person who ran the pawn shop near which accused person was lying ambushed, but I do not know the name. At the time, pawn shop was open. My lord, that police did not. I know the person who ran the pawn shop near which the accused was lying ambushed, but I do not know the name. He does not know. At that time, pawn shop was open. Some youth were present near the shop. Not examined. I stated before the police I had seen the owner of the pawn shop, other with there. Police recorded my statement only on the date of occurrence. Thereafter, I did not make any statement before the police. Exhibit 5 was a written paper where I put my signature therein. The content of Exhibit 5 not read out me. At the time of Exhibit 5, Gunabala was not present in the place of occurrence. That Exhibit 5 Milo was never written before him. He does not know about the content of Exhibit 5 Milo. That is the Caesar list, Milo. And Gunabala was also not present. I did not state before the police that the incident had taken place around 6:30 p.m. on the day, about 6 in the afternoon on the day. In police, he said 6:30 p.m. Milo. They Kusal Deka had a quarrel, took the accused person. In course of quarrel, accused person threatened they would cut the exit. I also did not state before the police on the date of occurrence. Accused person was lying ambushed near a pawn shop. That seeing the accused person has hide himself by covering their head faces. Time of leaving when Kusal Dekar asked to accompany him, I told to leave, my lord. That statement was he never made before the my lord police. First time he made this statement before the my lord court. It is not the fact that I did not state before the police that Kusal had arrived in front of his house. Eku Dipangar cut hold of his hand, Ekus Mukul Dekar's son on the neck knife. It is not the fact that was not stated before the police also. It was not fact that I did not state before police. When Kusal had shouted, the wife Kunabala had come out, then Ekus fled away bicycle. Lot of turn up there, and that being Gunabala told us the incident. This is incident not said by the Gunabala Mala. She never said all these things. And she said, I have heard all these things from the Gunabala Mala, PW1. And more interesting thing, this is the first time stated before the Mala court, all these things, Mala. It is not a fact that I did not state police that I found Ripun Deka, Arun Tamule, other people at the occurrence. That I took the dead body to the police on handcuff. The police accused person that on being asked, accused persons confessed the guilt. In before police, my lord, there is a confession. There is no evidence in the eye of law, my lord. And that I do not remember as to who informed the police about the incident. He did not remember, my lord, who informed the police. On the following, the accompanying Ganawala, she went to PS Loss Azahar. It is not a fact on the day police did not record my statement. It is not a fact I have falsely the accused person killed Kusal. It is not a fact. Kusal may knife, please see. It is not a fact. Lost sister-in-law on the ground. It is not a fact. Gunabala did not tell me kill Kusal. Now you all also kindly go to the evidence of Mala IO again. EW5 Mala. Page 32. Second paragraph. Is the PW5. Unil Deka did not tell me that when Kusal had sneezed their house, accused Dipankar held him, his hand, Mukul shot Kusal neck, that when Kusal screamed, Gunabala came, and the accused person left the place by bicycle. That many persons had gathered at the place of occurrence. That statement has been first time made before the court, my lord. That he heard from the Gunabala, that statement, my lord. On being asked, Gunamala narrated the incident that he seen the Ripun of other person the place of occurrence, that he carried the dead body and Puskar. Police arrested the accused person. That statement was never made before. They confessed to have committed the offense. That was also noted. Then your lordship kindly come to PW6. The person from whose house knife has been recovered, my lord. Page 23, my lord. And I have seen, my lord, this is not that leading to discovery by the accused person also, my lord. Also, the prosecution tried to project it that this was a leading to discovery under section 27 of Evidence Act. But that is not found in the incident, my lord. Let's kindly go to the evidence, my lord. I know the accused person. On the day about 6-7 years ago, I saw police taking Mukul Deka to her house, my lord. Herself. 2 knives were recovered from the backside of our house. But the statement of the accused person were not exhibited, nor IO in his statement has categorically stated that these were recovered from as per statement of this person's statement, these were recovered, my lord. If they follow the judgment of our full bench, my lord, that was also not done in the instant case. Police obtained my signature in Exhibit 2, Caesar list saying recovery of knife. Exhibit 2-3 is the signature therein. On the following day, my statement was recorded in court. Exhibit 5 is my statement. Exhibit 5-1, 5-2, my signature. Police questioned me of the incident. Then cross part, my lord. No boundary was around my homestead. It is an open one. No boundary, my lord. Open place, my lord. There was a village road on the backside of our house. Any person coming through the road can enter into our house through the backside of the house. I was not present while police visited our house. He was not present when police come to their house. On my arrival home, I came to know police visiting our house. I did not see police recovering two knife from the backside of my house. He did not see, my lord, all these things, my lord. And he is the Caesar witness in this case. My lord. The member of my family also did not see the recovery of knife. Police called me to the PS on being asked by police. I put my signature on the paper. In the PS, I came to know from the police about recovery of two knife. First time he know from the police, the two knife has been recovered. At the time of putting my signature, exhibit 2 was in blank. The Caesar list was blank when we put the signature. Police obtained my signature saying that I would to depose as a witness. At the time putting my signature, police did not show me any knife. Even they did not show the knife to the Caesar witness also. At that time of putting my signature, I did not find any people of our village there. At the time, I did not see Ripun Deka, Arun Denmuli, Munikanta Patwari there. I have not seen two knife in the court today. Except the recovery of two, I got no information from the police. Police took me to the vehicle exhibit 5. Police tutored me how to make my statement. How 164 statement taken by the prosecution. He was tutored about how he gave the 164 statement, my lord. Out of fear, I made the statement exhibit 5 before the magistrate as tutored by the police. Except for that, I know nothing about the incident. Meaning thereby, they have, my lord, threatened the witnesses also to give 164 statement. And on the basis of all this statement, the accused was convicted for life. Now he is 6 years in jail. PW7, my lord. Munikanta Patwari, my lord. I know the two accused person. Again, my lord, they are not identified in the doc. I do not know Kusal Deka. This is the incident took place 7-8 years ago. On the day of incident, I went to deliver goods. Later on, I wife informed that police had first gone to the house of the accused, then our house. On being called, I went to PS.
Just check out this deposition of PW7. This third line.
Is it in English?
Perhaps it's in Assamese and it's not readable. And just see PW7. It's in Assamese, but it's really difficult. If my learned friend can read, well and good. Also, I cannot resist that.
আৰু তো অসমীয়া জনা কৈ দিবা PW7 কোনটো
Third line.
Yes, ma'am. পিছত মোৰ পৰিবাৰে কয় যে পুলিচে আসামী ঘৰত গৈ আমাৰ ঘৰত আহে thereafter my wife has said that the police has come to our house মোৰ ঘৰত মোক মাতা থানাত গৈছিলো meaning thereby that I have visited the police station.
On being called.
Yes. On being called by them. Police.
Okay. The same, I think.
Later on, wife informed police had first gone to our house, accused then our house. On being called, I went to the police station, visited the house of Olokes. Exhibit 24 is the Exhibit 24 is my signature. Exhibit 2 is the Caesar list. police told me that as they visited the house of my neighbor Olokes, I had to put signature on some paper. I do not know what is written in the signature on which I put my signature. This is one of the seizure witnesses. The content of the same was not read to me, my lord. He does not know what is the content of the, my lord, seizure list. I did not see any person of our village while police obtained my signature. I did not see any person or while police obtained my signature. Meaning thereby when he was put the signature in the seizure list, no one is available from their villages, my lord. He was alone in the place of a police station, my lord. The 100 section 100 said two witnesses, my lord, come to the police station, sign together, my lord, who has knowledge about the recovery of all these things. That was not done in the instant case, man. The article at the putting my signature. Today, I have not seen any article in the court. He did not. Police did not question me. Then PW8, my lord, Dr. my lord, on 28/7/2008, I was working at Borpeta Civil Hospital. On that day, performed postmortem examination of Kusal Deka, ages for requisition, identified constable Hirendra Varale and found average male body. Body was pale in appearance. There is a blood clot in the neck and clothed uppercut of the body. Rigor mortis is present. Multiple cut injury exposing having on the right side of the neck. Facial of both side neck has been cutting also exposed. There was a fracture 4 to 6 cervical vertebrae. Approximate time of death 6 to 10 hours, my lord. And my lord, it was done on 27/8/2018, my lord. Next day, but time was not mentioned. I have to go to the postmortem. At 6 to 10 years. In my opinion, death was due to shock and hemorrhage as a result of injury was sustained. I conducted postmortem at 11:50 a.m. Without inquest report, PM is not conducted. If your lordship take this 11:50 a.m., my lord, then it will be time is about, my lord, the time of death is 1:30 to 2 p.m., my lord. Because if you take the maximum time, 10 hours, my lord, 6 to 10 hours, my lord. Then also time of death is 1:30 to 10 hours, my lord. Then either this incident was not taken place, or at that time, my lord, this person is alive. But there is no evidence I found the accused person was alive when he was taken to the, my lord, hospital. Immediately he was taken to the hospital, my lord.
No, occurrence took place 8:50, isn't it?
There are two times, my lord. One is 8:50. Another time is 7. We take the 8:50, my lord. Assuming, another meeting. 8:50.
Assuming 8:50
Yes, my lord.
and the postmortem was done at 11:50.
11:50 on next day, my lord.
11:50 the next day.
Next day, my
So
lord.
it is
Because
more-
incident took place at night, my lord.
It is more than 6 hours.
More than 6 to 10 hours, my lord. It about, my lord, my
So
lord.
he said approximate time of death was 6 to 10 hours.
Yes, my lord. If it is, it's assuming it is a 10 hours. 11:50. If we take 11:50 or 12, my lord. You're also coming back again, my lord, for in 10 hours, my lord. Then it is 2 p.m. or 1:50, or 2 a.m. or 1:50 a.m., my lord. But incident took place 7:50, 8:50 p.m. Then what happened, my lord? Because at that time when he was taken, he was not, my lord, there is no evidence to show he was alive. That is not available, my lord. That is the preponderance probability.
No, I don't understand what you are trying to project.
I want to project the case, my lord, that the incident took place at 8:50 p.m., my lord.
Correct.
He was immediately taken to the hospital. There is no evidence to show at that time the deceased person was alive. There is no evidence. When we go through all this evidence, my lord.
No, PW1 statement says
Yes, my lord.
he died on the spot, isn't it?
Yes, my lord. If that is so, my lord, that incident took place, my lord, 1:50 1:50 a.m. or 2 a.m., my lord. 6 to 10 hours, my lord.
6 to 18 hours.
6 to 10 hours.
6 to 18 hours.
6 to 10 hours. Approximate time of death was 6 to 10 hours.
But sir, page 73, it is 18 hours.
28, page 28.
Now postmortem report, it is
This is the evidence, my lord. Page 28 of the doctor, my lord. Page 28.
postmortem report, Lordship will see at page 73. It is 16 to 18 hours.
6 to 18 hours.
6 to 18 hours. So it will be around 15 hours from the time of death to the time of examination.
My lord,
Examination was on 11:30 next day. So from 9 to 11:30 will be around 15 hours. So he said 6 to 18 hours. Within that.
6 to 10 hours, he said.
Here it's up now, postmortem.
Postmortem টো
73
আনিম মই, পিছত তোমাৰ বেলেগ এখন document লৈ আনিম। সেইটো তোমাৰ পৰা
is
argument
developing his argument.
Yes, ma'am. Okay, proceed. Yes, ma'am. Exhibit 6 is my report. Exhibit 6(1) is my signature. I conducted postmortem at 11:30 p.m. without inquest PM is not conducted. Exhibit 6, I have not mentioned no inquest report on requisition of this copy. PW 9, page 29. Milo. IO Milo. On 27/7/2008, when I was working at Sapthebari PS, the OC of the PS received an Azahar, entrusted me with the charge of investigation. Upon visiting the place of occurrence, I recorded the statement of the witnesses due case map at the place of occurrence. That is important, my lord. Case map is very much important in this case, my lord. I held inquest on the dead body of Kushal Dekar. I sent the dead body for postmortem examination. I arrested the accused person. I seized the article, namely shirt found in the wearing of the deceased, dagger, plastic bag, sandal, shirt, one bicycle. Wearing of apparel has been seized, but it was not sent to the FSL Mal because there is a pool of blood. They have stated Mal. Exhibit 7 is the sketch map of the place of occurrence. Exhibit 7(1) is my signature. I seized one brown shirt stained with blood, one black bicycle, Hawaii sandal, plastic bag through exhibit 8 was my signature. Exhibit 1 was dagger, though exhibit 2 the scissor list. They said dagger was seized, exhibit 2. And the witness said by the knife, they were stabbed. Which is correct, my lord. The exhibit 2(4) is my signature. Exhibit 5 is the inquest report. Exhibit 5(2) is the signature then. After collecting the evidence, I submitted exhibit 9, the search sheet. Again, they could. I visited the place of occurrence at 9:50 p.m. on 27/7/2008. Immediately 8:30 incident took place, assuming my lord, PW1 is correct, my lord. Then 27/7/2008. He 9:50 come to the place of occurrence. On 27/7 on entry, on being 6:51 was made GDNT. That GDNT was never exhibited before the my lord, court, my lord. They are withholding this document from the investigation, my lord. As per GDNT, the place of occurrence is PW Road in front of the fire station, my lord. Very important, my lord. Incident took place in the PWD road near the fire station. I do not note down the distance of PWD road in the case diary. I did not write the GDNT as to which direction PWD road. PO is the preliminary investigation done on the basis of the said GDNT. Everything has been done through the GDNT. I draw the exhibit 7 on the basis of said GDNT. I recorded the statement of witness on the basis of GDNT. Even witness were examined on the basis of GDNT, my lord. I held inquest 8 a.m. on 28/7/2008. On the next day morning, inquest was done, my lord, in the place. The Azar was lost one day after the incident, 28/7/2008. I was not told the reason as to why the lodging in the Azar was got delayed. There is no reason, explanation from the part of the, my lord, informant, why there is a delay of filing FIR. The PS is 1 furlong away from the place of occurrence. That's 1 furlong, my lord. And it 10 minutes to cover the distance. I prepared exhibit 7. The case was registered 28/7. Though I prepared exhibit 7 on 27/7, 28/7, I mentioned I prepared I lodging there is no mention GD entry. Exhibit 7. Exhibit 7 shown me at the PSO PW Road at Sottebari. Exhibit 7 did not show the exact place PW Road where the incident had taken, the house of deceased and the fire station near the place of occurrence, but I did not record the statement of employee of fire station. The incident took place in front of the fire station before the PWD road, which is 300 meters away, my lord, as per sketch map, my lord. But no one has examined from the, my lord, fire station. And the night incident took place. On the other hand, my lord, accused house is, my lord, 300 meters away from the place of occurrence. I have not seized the article in the court today. I did not get exhibit shown by any magistrate. It is not a fact that I prepared exhibit 8 on my own, submitted the same. I did not make as to who had the seized site belonged to, and I did not get bloodstain on examined ascertain whose bloodstain those were. That means that was not examined. I did not make enquiry as who had recovered the bicycle, bag, and sandal. I did not record the statement of seizure witness, namely Krishna Deka and Gogon Deka. They were not examined, their statement were not recorded. I did not mention the reason of the same will. On 29/7/2008, I seized the article prepared by the seizure list, exhibit 2, I seizure list seen. Exhibit 2, all the witnesses already said, we do not know the content of the seizure list. At that time, both were not present together, that evidence also there. But I did not mention the reason why I got the seizure list seen in the court 1 day later. He shown the seizure on the next day. It is mentioned that exhibit 2 that no bloodstain was seen on the 2 seized dagger. I did not mention 2 dagger had seen was with the water. Important thing is that, my lord, if your lordship, there is a dagger or knife, anything, my lord, if someone has, my lord, wash out the blood also, then bloodstain found, my lord, in the FSL report also, my lord. Never that will wipe out, my lord, totally, my lord. But that was not sent to the FSL also, my lord. And people say that when we see that there is a pool of blood, my lord, whether this weapon has been used in this incident or not, we do not know. There is a, my lord, reasonable doubt about using this instead. I did not send to dagger FSL. If there were thumb impression on them, I did not seize the article in the court today. Even they did not take the, my lord, fingerprint of the accused persons, my lord. They, because seize that thumb impression found in the, my lord, the fingerprint found in the, my lord, dagger also. Either dagger or knife. Someone said knife, someone said dagger. That was not found in the, my lord, seizure, my lord, weapon, my lord. I did not receive any exhibit on. An inquest has to be held by the executive magistrate. I held on. I did not mention the reason I had held inquest 1 day later. I did a statement complaint 164 recorded in the statement 164 CRPC. I did not mention why the same was done day later. On the occurrence, I found the PW ... my lord. What is available, I do not know, my lord. One thing is important, my lord. 164 statement, the witnesses said they were Twitter, man. Witnesses category. And what they have stated in 164 statement, the accused person confessed before the police. What has been confessed before that has been stated in 164 statement. For these 2 reasons, my lord, this 164 statement cannot be acceptable, my lord. The entry 660 GD September was not made in connection with this case. I have not submitted copy of 651 dated 27 in this case. They have produced another GD entry number 660, but that was not connection with this day. Witness Gonobala, that has been that part I read, my lord, when I read these 2 witnesses. It is a not last part, my lord, page 32. It is not the accused person were involved in the incident. Case was lost against them, false ground. It is not fact. I did not seize the dagger's hand. The said article did not belong to the accused person. I have to show one thing, my lord. Main thing is that that's case map, my lord. Page ki mane? Page 74, 75. Seven. 74 miles, case map. Your lordship, kindly look. As rented house of this is Soldeka. This one is the house. Then PWD road. Next side, fire brigade office. And my lord, your lordship, there is some tree has been mentioned, my lord. Have your lordship got it?
Yes.
Tree. That is the place of occurrence, my lord. In the tree, my lord, place of occurrence. Then your lordship kindly come to the cultivable field, my lord. Number 1. Place of occurrence PWD road, Saktebari PWD road. Fire station and entrance house of the complainant at the distance of some 300 meters. Page 75, my lord. Not 300-meter distance, my lord. How can it be, my lord, 300-meter, my lord? A person at 8:50 p.m. saw this incident, my lord. And particularly when Sakhi, which has been used by Gunabala, was not seized in the instant case. This shows that there's every possibility Gunabala did not show all these things. And secondly, he developed his statement. I have already read my lord, PW10 statement, IO statement, my lord. That part which is seen when the accused person is fled away, first time made before the court. Earlier, she did not say anything about this thing. So far, regarding PW5, who is the hearsay witness, said about the Gunamala, said all these things. She never stated nothing about all these things, my lord. This document shows that this incident took place 300 meters away from the place or other in a dark night, my lord. And this, there is a preponderance probability that accused person has not committed these things, my lord. Next, my lord. Page, my lord, Caesar list, my lord. That is my MR Caesar list, my lord. Page next 76. One full sleeve shirt obtained with blood. Have you lordship got it? Description of C's article. One black bicycle, a pair of plastic sandal, one plastic bag, white hair. First part, one full sleeve brown shirt obtained with blood. But they are not examining any witness. Gagan Deka was not examined. Sondokando Roy was not examined. Krishna Deka was not examined. All 3 witnesses. Then your lordship come to the exhibit to cases. Then witness of inquest, my lord. Only Onil Deka was examined, Upen Deka was not examined. It took a signature component. Later eligible. Subhas Tambuli was not examined. Subhas Tambuli was not examined, my lord. Then Alokas Burman's statement, my lord. He said, Alokas Burman has said he was tweeted by the police. 164 statement.
Do you want to say anything is there?
Yes, my lord. I shall go to the one thing. Just one thing, my lord. Exhibit 2, my lord. Page 57, my lord. As per that, my lord, this article is one double-bladed iron knife with a wooden handle. Description of this article, my lord. I am reading that part, my lord. Page 57. I, ASI Subodh Haloy of Sathebari PS do hereby seize the below descriptive weapon in connection above referred case. Let identify to police witness of accused Mukul Deka, Sathebari PS at 9 p.m. which keep concealed in the hand of Alokesh Burman, Siri Bhavesh Burman, Kusal Deka night at 8:50 p.m. on 27/7. After committing the 27, the seizure has been made in presence of below assigned witnesses. My lord, these statements were never, accused statement were never exhibited by the prosecution before the, my lord, court in the instant case. Secondly, IO never stated that Mukul Daka has said that he has concealed the weapon in the house of Alokesh Burman. That statement was not available. So, my lord, section 27 was not followed, my lord. Section 27, if not followed, my lord, that seizure is no value in the eye of law, my lord. Whereas Section 27 has categorically stated the statement should be there either or police has stated that this statement has been stated before me, my lord. One Badal with a handle, and second, my lord, that witness. Arun Tamule was not examined, my lord. Arun Tamule, Ripun Deka has never said the content has been put. Monikanta Baptore never said the content of the, my lord, seizure list was proved. And Alokesh Burman has said that he does not know anything about this thing. Monikanta Baptore also said he does not know anything about it. Monikanta Baptore excellent question. Ripun Deka also said. Yes, sir.
আপনি সাইডে লাগে না তো অনলাইন কিমান করব জাজমেন্ট আছে জাজমেন্ট কিমান না वो कैलिफोर्निया की नहीं next week
আমি প্রিফারেন্স করবি মানে জানবেন করে বিনা দিলীপ দাস সত্যনারায়ণ তুমি বাকি দিলে যে দাদা আপনার কাছে সত্যনারায়ণ তুমি বাকি দিলে কি পেয়েছে নিরঞ্জন না হয় অসমীয়া ছোৱালী বিয়া হয় Now I read the 113 statement, my lord, of the accused person, my lord, page 33, my lord. Yeah. Can I read, my lord? Page 33. PW1 Gunobala Deka stated on the fateful day at about 8:30 p.m. while her husband Kusal Deka was proceeding to home, near the home, murdered her husband by inflicting knife blow. She, on hearing alarm of her husband, rushed to the spot and found you fled away on a bicycle with carrying knife. Your hand. She saw cut injury on the neck by knife, and she filed Azahar Exhibit 1. The knife was seized. What is your say? I want to say, my lord, what in question number 1 has said, which has been stated first time before the court, my lord. Only that part has been stated before the court, my lord. And one important thing is that in cross-examination, my lord, there is a, my lord, evidence has come, my lord, in cross-examination that the place of occurrence is 12 feet away, my lord. That question was never put in the 113 statement. So this evidence cannot be taken by the learned court below, my lord, for convicting the accused person. Because 313, that question was not asked, my lord. Question number 2. Because, and another thing is prosecution should stand their case on their own legs, not from the defense of the my lord, of the defense my lord, from the defense my lord. And despite of the moreover, that question was not asked in 330 statement. PW2, Ripon Daka has stated that he heard that Kusal Daka murdered at night next day. He saw you in the police station with the disease of the death, cut injury on the neck, police 26 knife, which statement recorded. Exhibit 2 in his statement recorded. Height exhibit 3, what is your state? The statement made in the police station, my lord, before any person, my lord, is not admissible evidence as per law, my lord. I shall put this some judgment later on, my lord. PWT, Arun Damuli stated on the fateful day at about 8 p.m. we heard the physical assault, Kusal Deka. Next day, police station, you confessed before public that you murdered the Deka by means of nice statement recorded. Both 2, 3 are hearsay witness. Second, the statement made before the police officer, man. No value, man. PW4, Sandakanta Roy stated he heard you cause death of Kusal Deka. He saw cut injury on the neck of the dead. What is your so? No, it is not so. He is also hearsay witness, my lord. PW5, Onil Deka has stated that on the fateful day in the afternoon, you had a quarrel of disease for money. You threatened the deceased to take life on the same day evening. He kept hiding near a shop. You covered your face to see him. Kusal Deka reached near home. You inflicted injury on his neck by knife while dipping the cornhole his hand. And due to raising alarm by Kusal Gunawala rushed to the place, you fled away bicycle cutting his mate. Police made inquest on the dead body. If your lordship go Onil Deka's statement, my lord, he is a hearsay witness. And what he has stated, he is hearing from other persons, my lord. So, my lord, this statement is no evidentiary value in the eye of law, my lord. Except PW1, my lord, other are all hearsay witnesses, my lord. Subject to correction of my learned P, my lord. BW6 Alokesh Burma stated police you took his house, found 2 knives behind his house, and recorded his statement exhibit 5. What is you say? No, it is not so. So PW6 categorically stated, I do not know what is in the content on the seizure list. The knife were not shown to him also, my lord. And some places he said, I think Degar. And he said categorically he was tutored by the police. Next, PW Monikanta Patel taken, you are near the house, sign, fight exhibit. What is your say? No question of recovery of knife is available in respect of Monikanta. He is the seizure witness, my lord. And no question has been made to him, my lord. PW there, Ajit Sarkar stated he conducted postmortem examination of the dead body. Kusal Deka found dead was due to shock and hemorrhage as a result of injury sustained. File report. What is as I did not hack, my lord. That question number 8, my lord. What is your say about this? Exhibit 6. One thing is, important thing is that, my lord, regarding the time of death, there is no question from the medical doctor. And he, ocular evidence said 6 to 10 a.m., my lord. If the learned court below has taken the postmortem report as a, my lord, evidence of this case, that question has to be put in 313 statement. That was not there. We have to go to the, my lord, statement made. And if 2 views are possible, views supported to the accused person will take, my lord. That is the law, my lord. PW9, Subhash Chandra Halo stated he was given to investigate case. Accordingly, he visited the place and recorded the statement of witness who was hurt, injured, 1 bicycle, suppal, stick. So, case made and exhibit searched against. What is your say? False case has been lost against me. What do you say? Yes, I will. If your law goes to the 313 statement, my lord, there are some statement only taken which has been first time said by the PW1 before the, my lord, court. Nothing more than that, my lord. And other PW1 for other witnesses, I have already, they are all hearsay witnesses, my lord. And seizure witness has denied the seizure in this case, my lord. The Sakki, which has been used by the PW1, was not seized in the instant case, my lord, which is the fatal. And it was a dark night, it was admitted by the PW1. It is a dark night, my lord. And Exhibit 7 has categorically stated that it is 300 meters away from the place of occurrence, my lord. That is, if that is so, my lord, the incident took place at 300 meters, a possibility 300 meters away. How can a person with a naked eye, because Sakti was not seized, saw that incident which has been happened in 300 meters away? My that is argument, my lord.
The postmortem report.
Yes, my lord. Postmortem report, my lord. Page 68 to 73. Julie, ডাঙৰখন আছে নেকি? চব টুকুৰা টুকুৰা কৰি আছে। ডাঙৰ postmortem report. Postmortem page 68, my lord.
Yeah.
69, my lord, external appearance, own position, character, cartoon in the neck, illegible, extended by the oblique, direction 7 cm, 4 cm, 5 cm, size, exposial onto curvial spine, corted vessel in right side has been cut down, cut word, cartoon illegible, 5 cm, 4 cm, 5 cm in size, orbital posterity due to cut on, multiple small cut on in size in plain palm area to left hand and finger. Cut on illegible part, neck, exponic and larynx. Larynx. Acha, down আছে নেকি তাতে? It's of illegible লেখছে। হয়। They are illegible write down, my lord. Maximum place.
The first one.
Illegible কেটা কৈ দিয়া না তুমি।
Cut wound in the neck. Vertical extending.
Vertically.
Yes. Or I cannot make out it.
Next, do number 2.
What is it? Vertically.
No, not vertical.
One is vertically.
Huh? No, may not be. Second one, cut wound. Aspect. Difficult to read. First one, Lordship can try once. It's in English.
Magnified rascal like.
The sellotape is attached to that, and so the words got smudged.
Oh. It's just not, isn't it? No. Internet.
Number two, cartoon.
Second one is also neck something, extend neck, the second line of the second injury. I think the injuries were on the neck, first and second.
Next, my lord. Or mark of ligation on neck, no mark ligation of neck. Scalp healthy. Thorax healthy. Number 3, larynx, cartoon in the larynx.
You can skip all this.
Yes, ma'am. That part, my lord, page 72.
Yes.
Average bill, more detailed description of injury disease. Average bill, male body, pale in appearance, sign on blood clot in the neck, hairy cleft, rigor mortis present, multiple throat injury, exposure leading lesion of facial in the right side of the neck being cut. My lord, if your lordship go to the that my rigor mortis is present, rigor mortis started my lord 6 to 8 hours, subject to correction, and rigor mortis will my lord finish in 12 hours, my lord. After 12 hours, rigor mortis will not be available, my lord.
This is summers,
Uh,
because it differs with the season. This is summers, this is July.
that is not available, my lord. Rigor mortis. That is why I am arguing the time. Age of the own serve, ever blood clot in the own fracture of 5-6 vertebrae from posterior aspect due to cut bone. Injuries are antemortem. Now I am, my lord, some judgment, my lord. Yeah. Well, I'm sorry, my lord. One paper book I have lost somewhere, my lord. There are 2 paper book, my lord. And to morning I give the, my lord, book list also.
Will require to, no.
My paper book is available. Other I prepared 2 paper books. Now one paper book I could not found in the morning my chamber one. That is the judgment, man. In this paper.
Produce it tomorrow.
Yes, ma'am. Huh? Copy this one.
Oh, you've done.
Yes,
You
ma'am.
print it out. Okay.
Okay, ma'am. Click on it. First, my lord, in respect of statement made before the police officer, my lord. 2015 11 SSC 31, my lord. Lordship stately come to the para 16, my lord, of that judgment, my lord. Page 8, inner page 38, my lord. 2015 11 SSC 31. Lordship kindly come to page 38. In paper book 38, my lord. Paper book inner page 8, my lord. Paragraph 16, page 38, my lord.
Indra Dalal.
Yes, Indra Dalal.
Indra Dalal, you are.
Yes, madam.
Paragraph 16.
Yes, my lord. Thus, philosophy behind the aforesaid provision is acceptance of a harsh reality that confession are extorted by the police officer. Have you also got it?
Paragraph 16 is something else.
Indra Dalal, my lord.
Indra Dalal.
Yes, my lord.
Paragraph 16 says as points 1 and 2 are interconnected.
Philosophy, my lord.
Hmm?
The philosophy. Para 16.
This is what?
Your lordship take my paper book. That is the inner page 8, man. Para 16, my lord. Of the
Mine
Indra.
is different. Yes, yes.
Yes, man.
Yes.
The philosophy behind the aforesaid provision is acceptance of a harsh reality that confession are extorted by the police officer by practicing oppression, torture, or even inducement, and they are unworthy of any credence. The provision absolutely exclude from evidence against the accused confession made by him to a police officer. The provision apply even those confessions which are made to a police officer who may not otherwise acting such. If he is a police officer and confession was made in his presence, that is important. They were taken, the accused person were taken up from the lockup, my lord, and confession has been made. That witness 2:5 has said, 2:4:5 have said, that is no evidentiary value. I have argued, my lord, made by a police officer. This, the provision absolutely exclude from the evidence against the accused confession made by him to a police officer. The provision apply even those confession are made to a police officer who may not otherwise act in such thing. If he is a police officer and confession was made in his presence in whatever capacity, the same become inadmissible in evidence. This is the substantial rule and this under the provision, and this strict rule has been reiterated countlessly by this court as well as the High Court. So the statement which has been made before the police officer, they gathered by the witnesses, is no evidentiary value in the eye of law, my lord, because they are in police custody. The word confession has nowhere has been defined. However, the court has resorted the dictionary meaning, explain, statement, accused police suggesting inference commission of the crime would amount to confession, therefore inadmissible under this provision. It is also defined to mean that direct acknowledgement of guilt not to admission incriminating act. However, according to section 26 of the evidence and make it all those confession inadmissible when they are made by any person while he is in the custody of a police officer, my lord. Hit by section 26 evidence act, my lord. While a person is in police custody, he made the confession before the police officer, no evidentiary value in the eye of law. Even it is, my lord, if it is 164 statement of the accused person, suppose it was not done in the instant case, 164 statement was taken from the police custody also, my lord, then also this is no evidentiary value. Accused person 164 statement has been got the magistrate also, my lord, evidentiary value. Always it will be taken from the judicial magistrate, my lord. But here in the instant case, some person, before some person, the confession has been made. Such confession made by the person while he is in the custody of a police, unless such confession is made, immediate presence of a magistrate. Therefore, when a person is in police custody, the confession made by even a third person, that to a other than police officer, shall also become not admissible, which has been done in the instant case, my lord. Thereafter has been stated, my lord. I am not reading all these things, my lord. Next paragraph also, my lord. Next 19 paragraph, my lord. Notwithstanding the same, the trial court as well High Court had relied upon the confession on the basis of the statement, coupled with other connected evidence available on the record, particularly recovery of scooter from the old house of accused Indor and disclosure confessional statement by FIR, dated so and so, so and so. What follow above the High Court is that confessional statement was supported with other evidence, though the High Court has mentioned other connected evidence that is relied for the record disclosed statement. No other evidence pointed out by the High Court on specific query. That is, my lord. Now, next I read, my lord. P.T. Anthony, my lord. Page, my lord, 2001, 6 SSC 181, my lord. Era 17, 18, 19, and 20, my lord. Huh? Era 17, 18, 19, 20. Page 195, my lord. Have you also got it?
Yes.
7, subsection 1 of section 154 contains 4 mandates to an officer in charge of a police station. The first enjoined that every information relating to commission of cognizable offense, if given orally, shall be reduced in writing. The second direct that it be read over to the informant, and third required that every such information, whether given writing or reduced writing, shall be signed by the informant. Fourth is that substance of the series. It will be no further that direct obtains substance 157. That is not important. Para 18. And information given under section 151 CRPC is commonly known the first information of, though the term is not used code. It is very important document as a nickname suggests it earliest cognizable offense. It says that that is also in 19. The scheme of CRPC is that offense of a police station commence investigation and provide 157 on the very anti-information coming to know of the commission of on completion of investigation, collector he has to form an opinion from 1/1970. However, even after filing of such, if we come to the position information material, he need not register a fresh affair. He is empowered to make further investigation normally.
It's also not required.
Not required. Here in that paragraph is, I think that FIR was to let. The second affair is no value in the eye of law, my lord. There can be.
We are not concerned with that.
Yes, my lord. From the above discussion, the first information is commission of a crime. Thus, there can be no second affair. Paragraph 20, my lord. And consequently, there are no fresh investigation on receipt of every subsequent information. Either receive some cognizable offense or the same occurrence incident giving rise to one or more cognizable offense. Paragraph 20 is important. On receipt of information about the cognizable offense incident given rise to cognizable offense, entering the FIR in a station house diary, the officer in charge has to investigate not merely account reported but also other connected offense found to have been committed in the same occurrence as the above. My humble submission before they have to GD&T investigation has been made. And this FIR is hit by 162 CRPC, my lord. If it is hit by 162 CRPC, my lord, it is not no value, my lord, nothing but 161 statement, my lord. Then, my lord, next important, my lord. I argued the case, my lord, starting my case, that case has to prove beyond all reasonable doubt by the prosecution. And my duty is to pose the preponderance probability. And you have to ask each and every question in your 313 statement. If that question was not asked in 313 statement, then, my lord, this is no evidentiary value in the eye of law, my lord. You cannot take this evidence for convicting the accused person, my lord. Your lordship, kindly, Rina Hazarika, my lord. Page 37 to 43. Para 12, 13, 14.
So TT Anthony, it's not relevant.
TT Anthony is 11, my lord. TT Anthony is 11 on the basis of that, this GD&T. The investigation has been done on the basis of GD&T. And this was not exhibited. The FIR has been, this is the second, FIR has been, my lord, this is the second information given to the police station, my lord. The written which has been, your lordship knows very well that FIR can be filed orally also, my lord, as per 154. The information has been received, investigation statement, witness evidence has been recorded.
It's not the second FIR.
This is the second, this is not second, I am not saying that. This is the second FIR. The first information is the first time he gave written. There are two information. One is oral information that has been given by that fire station man. And secondly, this FIR has been filed on next day, my lord.
Even then, it cannot be said to be a second FIR. It's not a second FIR.
Assuming but not admitting the fact it is not second FIR. Then the investigation has been started from the GD&T, my lord. So this FIR is no value in the eye of law, my lord. Normally what happened, my lord, when we give the information, that is called first information, my lord. That GD&T which has been registered on the orally given on telephonic call. This is the first information. That has been reported. That is called first information, my lord. And written form, it was given on next day. This is the first information there. This is the second information report. But they have registered as a first information report. That is the thing. Whole investigation has been done on the basis of GD entry, my lord. Even witness statement has been recorded. Tomorrow I shall produce the my lord, more good judgment to that aspect, my lord. It not only TT entry, there are other judgment also, my lord.
It is there, but in the concept of calling it a second information.
This is second information, if your lordship is correctly said, but it is a first information report. Report is first, but it is a second information.
But it's not a second FIR. Maybe a second information.
Yes, my lord, this is a
In
second
that-
information.
in
Yes,
that
correct, my lord. Now I understood, my lord. I understood that.
I don't think it's.
Yes, ma'am. Tomorrow I shall produce another judgment, my lord. Then your lordship,
You are not concluding today.
I shall conclude, I shall only give the judgment. I will take time, my lord. Sometime. Tomorrow I shall. At 2. Huh? I can.
This is out. Supplementary.
Tomorrow that another, it was because of my saying that it will not take long. Lordship took it up. But
Tomorrow, two.
this,
two
the
parts.
NDPS matter,
Yes.
and the NDPS is of course not part heard, but of course Lordship has heard bail application.
Then I shall try complete today, my lord.
But again, I have to say tomorrow.
তুমি যি কোৱা।
No, not
As
take
your
long,
lordship, my
we'll
lord.
finish it in half an hour's time.
On next Monday, otherwise.
I told you the beginning that we are not sitting after tomorrow.
Yes, yes, no.
Nine again.
Yes, tomorrow.
Oh, this court, this bench will not be sitting after tomorrow.
Let him finish today. I'll take tomorrow 10-15 minutes.
Yes, ma'am. I shall try to go fast, my lord.
Don't put too fast.
Yes, my lord.
Will not be able to understand anything.
Yes, my lord.
It's no point hearing them.
Yes, ma'am. Reena Hazarika, para 12, 13 and 14, my lord.
Just read the relevant para.
Yes, my lord. 12, my lord, that the postmortem reports of wound could not be caused by the small knife, alleged to be regarded for extract remote bone. I'm not, I'm directly coming to the my lord. Para 14, my lord. PW deposed that next morning 8 p.m. but PW7 deposed information was given by the police station by 12 p.m. On the general library met in the police 12:30. FIR registered on 7:45 p.m. There suspicious circumstances which leave enough time for planning. After thinking the matter, the allegations were deflecting that the occurrence took place in a manner other than what may have happened actually. Here in the instant case, my lord, FIR was registered, my lord, on the next day. There is every possibility, my lord, develop the case because there is no explanation from the informant why there is a delay of filing the FIR. Well, next 15, my lord, in the background of the discussion regarding the nature of manner, we deem it proper the said English translation of the paper book defense. The answer on the date of so and so, then message 16, paragraph 16, my lord. 313 CRPC cannot be seen as a OD ultim partem. It conferred a valuable right upon the accused to establish his innocence as can well be considered beyond statutory right as a constitutional right of a fair trial under Article 21 Constitution. Even it is not to be considered a piece of substantive reason not being owed under Section 312 CRPC. The importance of this right has been considered time and again by this court, but it yet remain to be applied in practice. We shall see presently in the discussion follow. If accused take defense after the prosecution is closed under Section 3, duty bound to consider the same, the mayor may not be held to confer a discretionary power to consider not to defend since its content, justice, likelihood, prejudice, that thereby whatever defense is acceptable or not, what is the compatible, incompatible, evidence entirely different matter. There will be no consideration at all defense under 313. It has given conviction may well be vitiated. To solemn duty of the court to dispense of the adequately consider the defense of the accused 313 to either accept or reject the same for the same reason. Here is the instant case. Many, I have not gone to the judgment also, my lord, that when the accused person was convicted, they are taken many things, my lord, which has been not discussed in 313, my lord. When the learned trial court has convicted the accused person, he has discussed many things in it. Why he has convicted the accused person for life. That was not discussed. One thing I have said, you have seen the incident 12 feet away, not seen the incident. The place of occurrence is 12 feet away. That was not discussed. Nothing has been discussed. What has been he said in 313? Only that part.
What is the finding in the trial court judgment?
That judgment may go to this manner. After going to the judgment part, I will go on that manner.
Trial court, if I may say, trial court considered PW1 as an eyewitness and relied. Because in her 161 statement, she said, I had seen it.
No, my lord. He is not correct, my lord. As
Lordship
per
can
trial
see the
court
judgment.
judgment, my lord, where evidence has said immediately after incident, he saw the accused person ran away from the place of occurrence. And that is the evidence.
Lordship, it's a small paragraph, eyewitness.
Mr. Chaudhary, I don't think you are concluding today.
Yes, ma'am.
Lordship can see just page number 54. Hence, in my view, though she is the wife of the accused, she is an eyewitness and then she was relied on. Page
But-
number 54.
But a witness say immediately after incident, she come, my lord. 313
Yes,
said.
No, I'm talking about trial court
Oh,
judgment.
trial court judgment.
Only trial court judgment.
Oh,
I'm not
That
going
my
into
lord-
the facts.
this my lord finding is vitiated. Witness himself said, my lord, immediately after the incident, I came to the place of occurrence. 313 also acts like this, my lord.
Okay. Mr. Chaudhary, when it comes to the appellant, also has done when additional PPM. Cutting part. This for Friday.
Tomorrow, my lord. No.
My lord, with all respect, my lord, lordship possibly rising, my lord. Attempt number 16, my lord, with all respect, my lord. It is in the hearing list, my lord.
Yes.
My lord, this matter has been coming up, my lord. We also took time at certain points of time. Now, my lord, what has happened, my lord? 389 applications are pending, my lord. Can your lordship fix a date, my lord? My lord, next week, my lord. At least, my lord, the 389 application may be disposed of because 128 number of witnesses. Hearing may take some time, my lord.
There is an order in 389 application saying that matter should be heard finally.
Already order was passed.
Already there is an order.
No, my lord. Yeah, exactly. She's also correct, my lord. I'm honest. She's correct, my lord. But my lord, as because my lord, many times it has come up for hearing, but it doesn't normally take. It is not taking place, my lord. So can this order be passed, my lord? Two applicants, my lord, with all respect, my lord. That, my lord, the 389 application may be heard next week, my lord. Otherwise, my lord, we are appearing every day, my lord, not getting a chance, my lord. And unnecessarily, in our understanding of the matter, my lord, it cannot be a case of 302, my lord. The deceased dies 6 days subsequently, my lord.
In which IA it was passed?
I remember it was passed, but I can take out.
Oh, no.
Really, it could be an only no
Yes. It's in the.
কি বলি আছে
Regarding the I have to consider.
আছে নাকি
304, so 304.
লোড
Pass I.
304, no?
105 or 106.
304 or 305.
যদি একটা হিয়ারিং বলে আসছে কি
না আমাদের মানে যদি হিয়ারিং নেই এটা কনসিডার করব ওয়ান
আছে নাকি
আছে মই কেন দেখতে পাবো না I 305 sorry no
my lord 6/9/21 my lord IA 305 my lord with all respect my lord And the date is, my lord, 6/9/21, my lord. Since the
So we have posted it for out of turn hearing. In your IA. We have posted it for out of turn hearing in the IA.
Out of turn.
my lord, my lord,
We have posted it for out of turn hearing in
My-
your 389 application.
my lord, my lord, my lord,
Then we'll fix a date for hearing.
my lord, any convenient date, my lord.
Give a date.
Oh, 7,
Next Thursday after.
8, my lord.
Third, Mr.
BK Mahajan, my lord.
DK Mahajan, counsel to the appellant in criminal appeal 135,
135, my lord.
2020, as well as M. Sarai. Counsel for in
17,
and criminal appeal 136, 2020, also heard as Jahan. This matter for hearing on, when do you want?
8/9, my lord, or 8/6, my lord.
It will be little difficult.
Next week.
We can have it on 13th or 15th.
Yes, yes. My lord, my lord, my lord,
13th.
my lord, highly obliged, my lord, obliged.
May it please your lordship,
Yes.
my lord. Item number 3 of today's list, my lord.
Yes.
My lord, can it be taken up on next Thursday, my lord?
What is
My
this?
friend is there.
Oh.
It's a short matter, my lord. Next Thursday.
First, Mr. Principal, counsel for the appellant. Also heard MS Pro, counsel for the respondent.
My lord. Thursday, right? 8.
8.
Eight.
8. Obliged.
Take care.